Why do you want to argue today?
No, I'm not arguing today. I'm only requesting if some fixed time can be given, not tomorrow also, any day, just 10 minutes time, because some direction is.
We'll see. If your matter reaches tomorrow, then you can.
Unless items.
We have 125 matters tomorrow.
That's why I was mentioning.
95 today. I'm hoping that the table won't break.
I leave it to Mandal.
Yes.
Your Lordship, I'm seeking permission to mention a matter. A matter was listed before Your Lordships for your consideration of criminal appeal. It has been dismissed by Your Lordships. Now, what has happened is that a second accused has filed an appeal with respect to the same impugned order. But it is not getting listed because the previous matter, cost title, includes the accused number for whom I appear.
Two real brothers accused. So we are seeking for
And how is it that his name was included in the earlier?
It was inadvertently included. We have rectified
I can't
it.
say inadvertently included them.
No, the only SLP has been filed by the.
Whatever it is, take it up with the registry.
Your Lordships have already.
You're not going to now start doing the work in the registry also.
Your
Sorry.
Lordships, the only.
We have enough matters today. Please don't make a mention. Whatever it is you wish to
It is
say to the registry.
Rectification before Your Lordship.
While you are IA, whatever it is, where's the question?
It is
Rectifying it on the oral
already,
mention.
already dismissed, my lord.
Well, where is the question then?
Your Lordship,
On an oral mention, you want us to change the cost title?
We are
The
pursuing
limit.
registry
There's a
since
limit
last
to
4
it.
months.
Sorry, pursue it with the registry. You don't.
Please, ma'am.
My lord, against the same impugned order, my lord. My lord already issued notice.
Which one is this?
Status quo. Yes, my lord.
The first item.
Even the first time, my lord.
Issue notice and tag with SLPC number 3042.
And same order, status quo order.
2023. It's
Yes,
there in that.
it is already there. It is.
There in
Your
that.
Lordship,
Yes,
Your Lordship,
Issue
I am
notice and
accepting.
tag.
Your Lordship, I am accepting notice on behalf of respondent number 129.
Note his name. One.
I am deeply obliged.
Oblige.
This wakalat, both the wakalats are also not the same.
Yeah,
It's
that's
not even a
exactly-
question of interpolation.
I'm not at all
We
saying.
don't say anything about taking action against the advocate who is supposed to have. Why would he be interested in altering? And on top of that, you say that you sign blank papers and give it. This kind of practice, if we start validating it by recognizing it, bad enough that it happens.
I understand.
And now you put it on paper that you give blank signed papers
Milords,
to the advocate and you want us to take.
He had said, Milords,
No question.
Milords, I understand, but the only problem is now.
Kumar Prasad, not in this matter.
Milords, I understand. The
The
only problem is that they are
Miscellaneous
feeling.
applications, these miscellaneous applications are utterly misconceived and we find no grounds whatsoever to interfere, to recall the earlier order and restore the special leave petition. The miscellaneous applications are dismissed.
Well, the only thing is that the litigants feel that he had not done anything which has.
I've also compared the wakalats, the
Yes.
two wakalats, the
Yes.
copy which they filed
Yes.
and now what you filed.
Yes.
And there's no question of interpolation because these are two separate wakalats. There wasn't enough gap there
Yes.
for any name to be interpolated.
What had
So
happened.
you obviously signed not only blank sheets, you also signed multiple wakalats.
Milords, that way, Milords.
Whatever it is, take it up with your advocate, sue him,
Milords,
and get your money out of the
it's
advocate.
not about money, Milords.
Whatever it is.
He's feeling as if something is coming from your lordship which he has not done.
We'll have to go by what is stated.
Milords, I understand. I understand.
Sorry.
Deeply obliged.
Item number 3, I'm requesting for a passover, Milords.
No passovers today, please. We have 95 matters.
Milords, Mr. Shobha-
Passover is sought, however,
Milords,
it is not possible to accept the request. List on.
Milords, may I request if it can be tomorrow or day after
No,
tomorrow?
we have too many matters. I'm not going to make the same mistake that I did. For some reason, I was fixated on 19th of January and I've been giving the same date in all matters. You can see the number of
Milords,
matters.
Milords, I'm only
Since
requesting if it
October.
can be on, if it
So literally a classic case of biting off more than I can chew. And unfortunately visiting it upon my brother also.
Milords, if it can be
So I'm not going to
Thursday.
make the same mistake.
Thursday, Milords.
No. Now, once you ask for a Passover, you go to the 27th February.
Milords, a bit-
Sorry, we don't have a date before that. In any event, you need to amend the cost title. These three are, respondents 1 to 3 are still minors.
Milords, they are the defendants, Milords.
They are minors still.
Milords, they
And
are
you
still
show them,
minors,
and you
Milords.
show them as represented by their deceased father.
That is what happened, Milords, in the High Court also, and they are
Then
still.
you need to take steps. A minor can't be represented by a dead father.
No, that's right, Manoj.
Well,
That's right.
do take steps in that regard also.
Manoj, I'll check whether they are still minor or major also, Manoj. That I'll check.
If they are not minors, you still need to file an application for getting them declared as majors. That also has not been done. Well,
I'll do that.
yes.
Manoj, the office report mentions there is actually another matter, the Ghaziabad development.
SLPC number 11107. But do you, whatever charges you have imposed upon them, do they come within this section 15 2A of the UP
There
urban
are
planning and development Act?
Manoj, there are zoning regulations which specifically mention this, which has not been
Justice
considered.
Shah's judgment doesn't apply to
Manoj, the zoning regulations have not been considered there, and that is why your lordships have issued notice in Ghaziabad Development Authority.
No, but it is identical. Isn't it?
Manoj, the zoning regulations have not been considered by this
Very well.
court.
Issue notice and tagged with SLPC number 11107 of 2024. Now you have to refund.
Yes, so Manoj,
Refund the
I'm saying
charge.
stay on that, Manoj.
Operation of the impugned judgment shall remain stayed till next year.
I'm grateful.
Item 5. How many such people are there? We have one in item 5 and maybe 5 in
5.1.
5.1.
Yes.
That earlier order,
Earlier order is, my lord, this is at page.
3rd December order, which the learned judge passed,
uh,
permitting all untainted, unselected candidates
Yes.
also to appear.
Hmm.
That order you did not challenge before us.
This is the order I am.
No, 3rd December.
No.
3rd
No,
December order.
that matter, your lordships have passed an interim order. That's it. And you come to page 281.
281.
It's a detailed order.
And here the elephant.
281 বার করো কি বলছে
Now, because that interim order is still standing, obviously the learned judge feels that the person should be permitted to appear for the interview.
Now, thereafter this order was passed, this interim order was passed. That your lordships have passed this order on 18 December 2025.
Yeah.
Regarding. Number this order has been passed on 12 December 2025. Before that.
Well, you'll have to take it up with the learned judge says place it in a sealed cover.
yes
No, this is the kind
They're
of
not going to
Madam,
step in
kind
each
excuse me.
stage.
Madam, excuse
You
me.
will have to address
Just kindly excuse me.
for the single judge.
Then we have to give it to the all the 2.6
How
lakhs.
many people are there?
2.6
This is the first
lakhs.
question. No. Why
No,
would
no,
it be
no,
2.6 lakhs?
Petitioners.
How many
Uh,
persons filed writ petitions on par with that Subish, whatever, that 3rd December order?
Subish, this is
That 3rd December interim order, how many cases was that similar order passed?
3rd December, after that, this order, this is the one petition. In another one matter, the other petitions are there.
3rd
And
December.
concluded.
but only few
Interview
not
has
large
been
number
concluded. Interview.
You're not telling us how many people who would be similarly situated to Zakir Hussain
Muller,
there.
3 or 4 or 5 persons are there.
That's all. Then what?
14 persons are there.
No.
Even 14 persons.
But an interview has been.
You're not required
But
to
an
give them
interview has,
appointment.
but an interview has been concluded.
my lord will not conclude or interfere in this matter with the best of
Cover and
respect
show it to the
No,
judge.
my lord, interview has been concluded. We have not taken his interview. We have not taken his interview.
When was the interview?
Interview has been finished long back. Only 8 January, my lord, last interview has been taken place.
8th January of this year.
Yes, tomorrow or day after tomorrow, we are going to publish the results.
This order was passed on 12th December.
12
ah
Why did you not comply with it?
We have filed on 18 December this matter.
Well, it didn't come up till now.
My lord, this matter has been filed on 18 December.
19th December.
Before this
they are
court, this
repeatedly
matter
not avoiding the
I
high
have
court
complied with the order
Well,
without
yes.
prejudice.
Well, 18 December we have filed it.
He said so.
Wait a minute.
Mr. Bhattacharya,
Yes, my lord.
on 18 December, when we passed that order, we also directed the 3rd December interim order to be placed in abeyance.
Yes.
Therefore, no benefit can flow from it till the High Court hears the matter finally.
That's our point. The High Court has fixed the matter. They did not appear.
But
They say,
in the meanwhile, the High Court is acting upon that interim order.
no. The High Court has.
The impugned order refers to the 3rd December order, which it
Yes.
could not have done because we've already kept it in abeyance.
Yes, Lordship not kept.
Before the
Very well.
order,
This was on
before
18
our order, it is not.
12th
That-
December
yes.
at that point of time.
It's not.
But in the meanwhile, the 3rd December order has gone into abeyance, so obviously they cannot.
But the difficulty is now, if the now ultimately in the petitioner succeeds, there will be much more difficulty. Therefore, the learned judge felt it should be.
If the High Court decides in your favor, you can always be interviewed at that point of time.
Well, that will create much more difficulty for them.
No, no.
But the
Why-
other
why
part
will
is
it
concerned. Well, the other part
Begin
is
with-
concerned, which is very
Begin
serious.
with Mr. Bhattacharya,
Yes.
because I've been in the bench which passed.
I know. Your lordship was there. I had to
Baisakhi
argue the matter.
Bhattacharya,
I know.
I'm there. Baisakhi Bhattacharya, what is it?
Yeah, Vaishakhi Bhattacharya. That's the principal case.
Now, in that judgment, it was never our intention to open the doors for untainted, unselected candidates.
No, the untainted, my lord.
Mr. Rahim, in
Untainted.
fact, had said that we approached the High Court and we are not
We-
getting any relief.
Waiting.
That was how it was.
The waiting list
Not
candidates are
planning on
also
opening
untainted.
the doors for all persons who were not untainted.
But my lord, the
To
judgment
again have a
itself,
second go. That
my
would
lord,
be
judgment
completely
is very clear, my lord, that it is
we
only
never said
applicable.
that. We never
Well,
said that untainted,
if-
unselected candidates.
That if situation arises, my lord, we can satisfy your lordship. But
Very
we are
well,
not on
sir.
that.
File your counter. We
at-
will stay this order.
Yes, sir.
This order
No,
needs to be.
My lord will kindly, my lord kindly stay, my lord, their portion where, my lord, the interview has to be taken, my lord, videographed. My lord, they are really manipulating. Again, they are manipulating.
Side, no interviews also at this stage.
But they have no interview, but the my lord, interview.
Direction of the High Court, we did the impugned interim order dated 12/12/2025, requiring the appellant, the petitioner commission to interview the candidates who were supposedly untainted but had not been selected in the 2016 selection by granting them age relaxation shall remain stayed in
Yes,
view
yes.
of the order dated 18/12/2025 passed by this court in
SLP number
page 241
281.
to 81.
That this stay is only in respect of age relaxation.
In
Not the next one.
SLPC number 35895 of 2025.
Where is confined to age relaxation only.
35895. No, it's a sentence. I've lost the sentence. In view of the fact that
5.1 answers, sir. 5.1 next one.
Not selected in the 2016 selection by granting them age relaxation shall remain in view of the order dated so and so passed by this court in so and so.
keeping the earlier interim order dated 3/12/2025 passed by the High Court in abeyance.
But the lordship also direct the authority to appear before the High Court and file their affidavit. They are avoiding the court.
Whatever you wish.
They are avoiding the court. No, this should not be encouraged.
What we are saying, we have 5.1 also similar.
Five-
Minor, one thing, may I indicate, because of that, 11-12 interview is completed, but 9-10 interview is not yet completed. And another aspect is 5.1,
But
kindly see
this
para
understanding of Baisakhi Bhattacharya.
I am not on that, Malad. I am not on that. Malad, kindly see 5.1
interviews at this stage.
in
Well,
camera.
very well, Milord, this is
Of these
No,
candidates
Malad, I am not on
by
that.
this stage.
Malad, kindly see, I am not on that, Malad. There is a direction in this order, Malad. Kindly see, Malad, 5.1 order. Para 12, Malad. Kindly see, Malad, para 12. There is a specific direction because in pursuance of Supreme Court order, the interview ought to take it in camera, my lord. That order is
We've
given.
never said that.
Yes, not, but this is Ajay, my,
State the orders.
We've made the interviews now.
kindly see the order, kindly see the order for once,
Please
my lord.
understand, we are not permitting interviews for them to be videographed now.
Not for us, my lord. Kindly see
Whoever it is, no videography at this.
my lord, para 12, my lord. Kindly see para 12, my lord.
Next matter.
Kindly see.
Arey, Fido,
If you're
Shukar.
appearing, file your counter. No
There should
more.
be some
arguments.
order to all this.
It is confined only to the age relaxation, nothing beyond that.
Yes.
Can we have 2 weeks for counter?
File your usual order.
My lord,
2 weeks and
List on,
list up to 4 weeks.
list on 10th March. Item 6, issue notice and tag delay condone. Issue notice and tag with civil appeal number 14783 of 2020.
There's also
my
notice
lord,
on the.
just
What is this council?
Your
Yeah,
matter is
Next
overcome.
matter.
Hirabhai,
Your matter
my lord,
is
this is
over.
Supreme Court dictum, my lord. Kindly see the Supreme Court
Well, it
dictum.
can't be applied across the board to
Yes, but
disputes
that's the
which are
dictum of
already
the Supreme
concluded.
Court. My lord, kindly see.
Council, is this how the West Bengal High Court?
No, my lord, kindly see
I'm
para
surprised.
14. Para 14, my lord, kindly
There
see.
will be
The matter is overcome.
Sorry,
Please understand.
Grateful, my lord. This is all for the end.
Anxiety should not extend
Malad,
to your
kindly-
stepping into the shoes of your client.
My lord,
You are
that
first
is
and
not
foremost
my
an
matter.
officer of this
Just
court.
respect, my lord.
Please maintain the discipline and decorum of
As
this
well,
court.
I go down, my lord.
Well,
But
you are not doing it.
I'm sorry, one request on item 6. There's notice on interim stay also in the main.
Very well. Issue notice on
Because there are many orders that are being passed.
especially petition as well as the prayer for interim relief
Obliged.
and tag with civil appeal.
Item 7.
Delay condoned, issue notice and tag with SLP criminal number 11588 of 2025.
My lords, there is an interim prayer.
In that, is there any interim order? Next matter.
Item 8.
Please, no, this is,
Please come to page 146.
Yes, ma'am.
You went before the Dubai court.
Yes, ma'am.
You've now got enhancement of the maintenance. And page 146, last sentence.
Yes, ma'am.
The plaintiff and the child are not entitled to any support from the defendant for any subsequent period in India after the date 2010-2022.
Please, no.
There's no question of you coming here and asking for further enhancement in India also.
He's not paying laws.
Even if he's not paying, you've chosen to go before the Dubai court.
Kindly see. Kindly.
We find no,
kindly.
we find no good ground and reason to interfere with the impugned judgment.
Laws, they are left in lurch, laws.
The special leave petition if accordingly dismissed. If you try to pursue too many remedies at the same time, you end up with no remedy at all.
Laws, may kindly see.
Well, you've gone to the Dubai court has said this.
No,
After
because-
22, you're not entitled to claim maintenance in India.
Please, no.
There ends the matter.
He was not paying.
You went to the Dubai court, therefore you invited this order, you're bound by it. No question. Next matter. Item 9, have you found him?
Could not find Malad.
Then we'll dismiss it on that.
Let there be.
Despite ample opportunity having been granted, the Union of India is unable to locate the respondent for effecting service of notice. In such circumstances, we cannot examine the grievance of the Union of India with regard to grant of bail to the respondent. The special leave petition is accordingly dismissed.
So the trial court can still issue non-bailable warrant for because
How
it's
will
not attended.
non-bailable warrant?
Yes.
Who is to execute it? Your police machinery.
That's true.
You're not able to find him.
But then, Malad,
Then what is it that the non-bailable warrant will achieve? Only dates before the trial court. They have enough matters on their docket. There's no need to burden it further.
Milord, this matter will be sent to the mediation, Milord. There is a possibility of the settlement.
You're for
I am for the respondent number 2.
Lordship, I make your
very mediation of it. Appear before the mediator on 19th February. Both are here?
Lordship.
The state is
Where are
not
they?
here.
Where are they?
I am for the complainant.
Very well, we'll give you an earlier date, 3rd February.
Much obliged.
here now the
Milord,
evidence
item
of
11 on
Earlier
the
interim
last.
order in that matter.
No, my lord,
interim
that's
order
the wrong
dated
statement.
15/5/25 shall stand extended till the next.
My lords, on the last
11.
date, there was a wrong statement made by the state that it is at the stage of cross-examination. The matter is still at the stage of examination in chief, my lord. And I've spoken to the public prosecutor in the trial court. He says he'll take 5 to 6 dates more, my lord.
Yes, and will be.
Been asking for adjournments time and again, my lord. It's been 3 months.
No, but the complainant has not been examined.
Not yet. It's still at the stage of examination in chief, my
Sorry?
lords.
he is in the witness box. His examination.
Why is it continuing for so long?
I really don't know. Why should it take such
My
a
lords,
long?
the public prosecutor says he will take 5 more dates, my lords. And every time the matter gets listed after 15 days, my lords. They call him at 3:30 and they close it at 3:45, my lords.
What is this?
My lords, on every date.
We are informed that the examination of the complainant is still ongoing before the trial court. We request the trial court to give priority to this matter and conclude the examination of the complainant at a stretch by taking up the matter on a daily basis to the extent possible. List on 20th February.
Lord.
Great.
Item 12.
I am for the petitioner.
You've received a copy of the counter. No passovers today. Have you received a copy of the second counter, 16 January?
Yeah, day before.
They say
Yes,
that
Lord,
you are
day
not
before yesterday I have
cooperating, you
received.
did
Lord,
not
I'll
come
file. Lord, I'll file rejoinder to their counter. Lord, there is much more which they have not
specifically say
brought
that
into my
you
Lord's
failed
notice.
to appear on the date which you were asked to come on.
My Lord, I have specific instructions. My Lord, I went there. My Lord, I even called the investigating officer 4 times, my Lord, but he didn't pick my call. Not each and every. My Lord, I am still ready to go. My Lord, may fix any date. My Lord, I'll again appear before the investigating officer.
In the light of the counter affidavit dated 16/1/2026, filed by the state, asserting that the petitioner failed to appear on 25/10/2025 to cooperate in the course of the investigation. We direct that the petitioner shall appear before the investigating officer on 3rd February, 2nd February at 11 a.m. The investigating officer shall make himself available on the said day for that purpose. Now, don't say that he's going out of.
Lord, there is an interim order. Not that may be continued.
Meanwhile, the petitioner is at liberty to file his rejoinder to the counter dated 16.
Lord, interim to continue, Lords.
Earlier interim order dated 25/8/2025 shall continue to operate till the next hearing. List on 20th February.
I am deeply obliged.
R8 is not served.
Yes,
R8, someone is appearing?
It was served.
R8 is not served. That is the office report. All other states you have shown as represented by the Chief Secretary. R8 is the state of Uttar Pradesh and you don't show that. So who will it go to?
I have an email from the email has sent me that there.
Well, we'll go by the office report which is dated 17th January.
Then I'll take.
And it says that R8 is not served. And I've looked at the cost title and you show R8 as not being represented by anybody. A state has to be represented, is it not? Who will it go to then? Obviously, it can't be served.
There is a
Office report dated 7/1/2020.
There's an interim application
Reflects that. Without, once notice has been ordered, it means that we wish to hear the other side before we take up your plea for interim relief. So 17/1/2026 reflects that respond number 8 has not been served. And counsel for the petitioner shall take necessary steps in that regard.
one small
Your Lordship, I am appearing on behalf of CB, respondent number 2. We will be filing our wakalat.
The served respondents are at liberty to file their counter affidavits within 2 weeks. Rejoinders by order. List on 27th.
Lordship, can I mark my appearance?
Please do.
Item 14.
Lord, look, see the last order sheet, Lord.
Yes.
This is that same case.
R3 has now filed a counter.
Yes, and what is happening is, Lord, after they lost in DRT, they go for FIR. Now, who goes for FIR? Not the bank. Auction purchaser. And in the DRT court, they've lost the case. For 6 years, they never denied those documents.
Mr. Tanka, we'll have to give you another date. This requires to be heard.
Lord, what I'm requesting, he's in jail for more than a year.
Yes, 19 December you went.
Yes,
but today is not the Muhurat for you.
Very well. I'll leave it to that. But could it be a short date, Milord, if possible? Because his wife, he's living with only his wife is there who's a cancer survivor. Nobody else in the family.
These are
Very
30th January.
good. Should we give a short note, Milord, with pages? With the Milord? Because the
counsel for the parties are at liberty.
13.
13 others. But why is your list showing me less number of matters?
Actually, advance list has come.
No, but
20 January.
update it.
Very
15. Done, counsel for the parties are at liberty to file brief written submission. That's 30th January.
30th. Grateful.
May I please, Your Worship, in this, she's cooperating with the police, but the police is giving her great torture. She's giving electric shock during investigation, everything, Your Worship.
According to the counter, she's admitted everything and
Because of the electric shock, they're making her write everything. They're just forced to sign this
19 of the counter, Milord.
And she's already paralyzed half, and she was not well, Your Worship.
Kindly see,
file a rejoinder. Without your filing a rejoinder, we can't take these kind of submissions. And counsel for the petitioner seeks time to file a rejoinder to the counter affidavit filed by the state list on 27th.
Don't you give me some time?
27th February.
She should continue to cooperate.
Interim order dated 9/10/2025 shall continue to operate till the next year. No third-degree methods, please. When we are seized of the matter, you're still feeling free.
Not for a lady.
Let us not be blind to the realities of what happens in this country. So, please advise them when we are seized of the matter not to use their usual tactics.
No, even otherwise, no.
Otherwise, you say that no third-degree methods are adopted by the police in this country. We'll hold you to that if you make such a statement.
I have different experiences. Whether it can be third degree in what sense, Milord?
I see. So their degree is within the third degree, according to you. Very good.
Lots.
Counter 5.
Miss Anisha Rastogi appears for the state version.
Who's for the petitioner? Item 16.
What is online?
Online? Counsel in item 16. Where is he?
Problem is there.
Problem is there.
My lords, he's not unmuted, my lord.
Yes. You have to unmute yourself at your end also, not just the officer here. Yes. Do you need to file a rejoinder to this counter? It was filed yesterday. Counsel, can you hear me? He's blank. We find the learned counsel for the petitioner is unable to address arguments due to online due to a glitch.
And somebody else is NK Majumdar. Unmute him.
Mr. Majumdar. He is muted on his side. Mr. Majumdar, you will have to unmute yourself. Anyway, we'll give you time to file a rejoinder. Please do it by the next date. unable to address arguments due to glitch on his side. He, time is granted for filing a rejoinder to the counter affidavit filed by the state. It shall be done by the next date, as short as possible. Too many orders, no? The rejoinder may be filed. Don't write all this also. Just say counter of the state, counter filed by the state, rejoinder, if any, may be filed by the next date of hearing. Interim protection granted on 26/9/25 shall continue to operate till the next hearing. List on 13th March.
Need to batch me.
Item 17.
May it please you, Lord, if I appear for the
Joint investigation.
The joint investigation and statement was recorded on 11th.
So there's no need for custodial interrogation.
There is the documents which are fabricated,
These are all
which have been
fabricated.
sent.
You,
and the
you don't
forensic-
expect him to sign a confession, do you? Then
Though the forensic report is awaited.
the leave branch, the appellant is. Today, not a day for final or 10/20/25 shall continue to operate till the next hearing. List on 9th, 10th March.
Item 18.
R2 is not served.
We are listening to the field police report. What sort of a bail?
In the morning.
R2 is not served. Without R2 being served, then
I'm appearing for the R2, Your Honor.
you're appearing?
Yes, sir.
You need to file a counter.
Yes, Your
It's
Honor.
against.
We have filed us, it's not on record yet. It's next. We have filed us.
You filed a counter?
It's not on record.
served it in the
It was served this morning, so it will come on record.
What is your name, counsel?
Bhuvnesh Mittal.
Bhuvnesh Mittal, and counsel states that is instructed to appear for respond number 2 in these matters. He is permitted to file his wakalat well before the next date of hearing, along with his counter affidavit. Learned counsel appearing for the state of Uttar Pradesh says that the counter affidavit was filed today morning. The registry is direct to verify.
Your Honor, the
Put up the
is also
same.
required to be.
Replies, rejoinder, if any, may be filed to both the counters before the next date of hearing, list on 13th March.
Which may extend the interim orders.
Earlier interim order dated 8/10/2024 shall continue to operate till the next year.
Item
Item
19.
19 and filing a wakalat on Saturday. No. Some time for filing a counter. I filed it for R1.
R1 is it?
Yes, sir.
You filed your wakalat also?
Please on Saturday, no.
And counsel for respond number 1. Your name is not shown though. Only counsel for.
It's on record in the portal, not on the listing. Saturday.
And counsel for response
Mr.
number
Ansel Jain
1
has filed the wakalat.
takes time to file a counter after usual order. Earlier interim order dated 3/12/2025 shall continue to operate till the next hearing. List on 23rd March.
Deemed to place.
Item 20.
20
Time
no
to file
counter.
counter.
Learned counsel appearing for the state within brackets NCT of Delhi takes time to file a counter affidavit. Usual order. List on 27th February.
Lord.
Obliged.
Item 21.
Your Lordship, I appeal for respond number 2 and 3, Your Lordship. I filed the counter on Saturday.
You filed it.
Filed
What about R1?
I am appealing for R1.
No counter?
No, I will file it. Your Lordship, last time.
You're on caveat also. And you didn't file a counter.
Because last time in matter appear, your Lordship said that your counter is not necessary.
We say your counter is not necessary.
Your Lordship
It is not for us to decide whether it is not for us to decide whether you should be filing a counter.
I will file it.
You're a respondent in the case. It's your call whether you wish to file a counter or not.
I will file it.
Learned counsel for respond number 2 and 3.
I filed on Saturday.
2 and 3 states that the counter affidavit was filed on Saturday's date, 17th. Registry is directed to verify and put up the same. Learned counsel for respond number 1 seeks some more time to do. To file his counter affidavit, which on the if any may be filed well before the next date of hearing, list on 20th March.
Item 22.
Your Lordship, Mr. Sridharan is appearing through VC.
Yes, differential duty has been paid.
No, according to the office report, they have not filed proof of. There was some amount.
Your Lordship, it has been paid.
But no proof filed?
Your Lordship, we have a receiving letter.
You can't keep it with you. You need to file it, is it?
Yes,
Anyhow, this matter perhaps requires a hearing.
We have filed our counter.
Counter is filed. Any need for a rejoinder?
Your Lordship, actually, there is a writ pending before the High Court.
Question is, do you wish to file a rejoinder?
We will file it.
Okay. Counsel for the petitioner seeks some time to file a rejoinder to the counter affidavit filed. Proof of payment of the differential duty shall also be filed along with the said rejoinder. List on, we'll take it up on Wednesday. March.
I think they're looking for a slightly longer date because they say they have filed some.
Your Lordship, you go through once the proceedings in the High Court.
High Court proceedings are
Yes.
still ongoing.
They have filed some ancillary proceedings according to us.
22nd April.
Much of that.
Item 23.
R1 no counter, R2 has filed.
Also, we have filed the rejoinder also.
You filed a rejoinder?
Yes, madam. We have filed the
To the counter of R2.
Yes, madam.
What about R1? No counter?
No counter. My lord, I have filed the counter affidavit. We have respondent number 2.
But respond number 1, who's appearing? Rotate. Because this involves a larger question because Anita Hada issue also arises here.
That is the only issue.
So that is the reason why we thought the state would also want to say something on the issue.
Actually, my lord, the question is that after acceptance of his part of the debt is after the lapse of 5 years.
Are you aware of Anita Hada?
Yeah, my lord, I have gone
Then
through that.
you have to answer
Yes, I
that
have.
issue then. And also,
We have filed the rejoinder.
fund number 1 has not chosen to file a counter affidavit. Last opportunity is granted to respond number 1 to do so. List on 23rd March.
Lord, there is an interim order.
Earlier order of state dated 23/3/2025 shall continue to operate till next year.
Obliged.
Item 24.
R3 no counter.
My lords, I'm seeking some more time.
You're for R3.
I'm appearing for R3.
Counsel for respond number 3 seeks some more time to file a counter affidavit. Usual order. Status quo order dated 25/8/2025 shall continue to operate till the next hearing. List on 25th March.
I'm so grateful. Item 25.
Lordship, I'm appearing for the petitioner, your lordship.
Counter affidavit in this?
No, lordship, you not received any counter affidavit.
R2 to 4 served, no one is appearing.
Yes, your lordship.
Who appears for R1? R1, someone has filed appearance.
Yes, your lordship, on 17th January, they filed appearance.
Mr. Ajay Kumar Srivastava.
Yes, your lordship.
Respondent numbers 2 to 4 have not chosen to enter appearance despite service of notice. Respondent number 1 has not filed a counter till date. Last opportunity is granted to the said respondent to do so by the next date of hearing. Within 2 weeks, you said. Within 2 weeks, rejoinder thereto, if any, may be filed within 2 weeks thereafter. Earlier order of stay dated 7/11/2025 shall continue to operate till the next hearing. List on 6th April.
Grateful, your lordship.
Item 26.
Lordship, I'm seeking 3 weeks' time to file the rejoinder.
Rejoinder. The counsel for the petitioner seeks time to file a rejoinder to the counter affidavit filed based on 6th April.
Pleasure.
Earlier interim order dated 13/10/2025 shall continue to operate till the next hearing.
Much obliged.
My lords, we have filed an application for substitution of the LR.
P1 died.
My lords,
P1 died.
my lords, all the legal hairs are already on record. We have
They're already on record.
My lords, we have mentioned in paragraph 5 of the application.
Very well, you'll still have to show them as representing P1 also.
My lords.
So IA numbers 314
7
777 and 314 778.
My lords,
IAs are ordered and the legal representatives of deceased petitioner number 1 are brought on record after setting aside the abatement in taking necessary steps in that regard.
my lords, I'm requesting.
Amended memo of party shall be filed within 2 weeks. What are you requesting?
2 weeks for rejoinder, my lords.
Rejoinder.
My lords, and status quo may be continued.
Rejoinder may be filed. Learned counsel for the petitioner seeks time to file a rejoinder to the counter affidavit of respondent numbers 1 to 5. Needful in that regard shall be done by the next date of hearing. Earlier order of status quo dated 16/7/2025 will stand extended till the next hearing. List on
May be kept on NMD.
On a non-miscellaneous day.
My lord.
Non-miscellaneous day, you'll be joining the queue there. Very well. 7th, 8th.
Obliged.
Item 28.
No counter affidavit.
No, my lord, counter has to be filed. The issue is whether the immunity granted by the.
You're for the respondent.
Yes, my lord.
You want time. Then counsel for the respondent seeks time to file a counter affidavit. Usual order. Earlier order of state dated 29/8/2025 shall continue to operate in the next hearing. List on 24th.
Grant 4 weeks.
24th.
Yes.
Item 29.
Counter file.
Just some time to file a rejoinder.
And counsel for the petitioner seeks time to file a rejoinder to the counter affidavit file. Usual order. Needful shall be done by the next date of hearing. Earlier order of status quo dated 4/9/2025 shall stand extended till the next hearing.
So much for the flood. No flood at all.
One 2026.
So in 31 we have filed Wakalanama.
For which respondent?
So respondent number first Abhishek Kumar.
1. 2 is not served. You file your counter.
Sure.
Reflects that respondent number 2 remains unserved. Steps shall be taken to complete service of notice upon the said respondent. Learned counsel for respondent number 1 seeks time to file a counter affidavit. Usual order. Then list on 17th.
Item 32.
Please, Malad, I'd like to agree about
Representing the respondent here, Malad, kindly allow me to file my counter affidavit. I'll file it.
Learned counsel for the respondent. Seeks time to file a counter affidavit. Usual order. 17th.
Malad, there is the interim relief granted on 21st of November.
21st of November, is it? I'm not noticed. Very earlier interim order dated 21/11/2021.
Obliged, Malad, deeply obliged.
Any specific date?
Yes, date. What is
7th of April.
7th of April.
Obliged.
Item 33, Malad, I'm seeking a pass-over, Malad. I'm being
No
held on-
Passovers today, please.
Then Malad, kindly keep it, Malad, on Friday or next Monday, please. I'm so
Leave the
sorry.
date to us. Passover is sought, however, the matter is adjourned. List on 3rd February.
No, Malad, kindly keep it next week if possible, please.
Not possible.
I'm so
Same situation will be there.
Yes.
If we clutter up the list, none of the matters will get heard.
Please, I'm grateful.
Item 34.
34 approval,
Amendment is still there.
up to
Waiting for the
approval, still waiting.
Still waiting.
How long will it continue?
Let's state.
What approval?
I would have to 4 weeks.
They've settled the matter.
Okay.
Just have it after 4 weeks.
And
This
the
thing is very
authority
clear.
has to settle, has to approve it.
Okay.
So because of that, approval is still awaited from respond number 2. Who appears for respond number 2?
Well, it's no one.
You are
There's
for?
no appearance.
You are for
The contesting.
R1. You are R1. List on 7th.
Obliged, Malad.
Pleasure.
May I please? Item 35, Malad, with the due apologies, Malad, I could not be filed additional evidence with it. I may be permitted to file additional evidence in 3 weeks.
Okay. Okay.
Additional evidence.
Evidence, Malad, no evidence is placed on the
Especially
record.
petition.
There are some eyewitnesses.
What do we
No,
do
no.
with
3 courts concurrently
Well,
found no injury, no
Nothing.
possession of
3
valuable
weeks as a lost chance.
eyewitness.
all of you are jewelers, and obviously the
Well, it's-
379 is dropped also.
The other
So your
provisions,
main
Malad,
sheet anchor is gone. That 5 lakh
May I
is
say
not
this-
jewelry.
may I say this, Malad?
With him bringing
May I
additional.
say this, Malad?
Evidence you can't.
May I say this, Malad? Just I wanted to show Malad.
Yes, sir.
Charge sheet kindly have paid 30 and 34 Malad.
Not ordered. No.
No.
It's,
It's
short and
adjournment.
There is
3 courts
Well, it is-
concurrently found that.
Malad, such is the case, Malad. I'm pointing out.
Where is the question?
Just
Bringing
pointing
evidence
out-
at the SLST
Just
stage.
let me say something, Malad. Kindly have charge sheet, page 30 and 34,
Where is the
para
question of-
3.
Where is the question of
My
looking
lord,
at the
370
charge sheet when
Even
3 courts have
379
acquitted?
goes, 379 goes, Malad. Other sections, Malad.
Nothing in it.
Other section, the investigating officer categorically stated that I was beaten.
However, we find no
341, 506, there are other provisions, Malad.
with the impugned judgment passed by the High Court.
This is all
Your
the-
petitions according
This
to
is one of the measures by which
There's no injury report also.
Injury report, Malad, just
I-
simply beaten, Malad.
Oh.
Where do I get injury report, Malad? I was beaten
You say
simply.
that you are beaten simply.
Somebody throws out a person, Malad, could not get any injury, such is the case, where do I get?
All courts have held against you. There's no question. You want to settle scores with your rival jewelers, you need to think of better ways of doing it.
No, Malad, I was beaten, Malad.
Nothing more.
Item 36.
at times you get beaten in
I'm
the
requesting for a password. I'm led by the Learned Solicitor General.
Malad, it may be taken up with item 90 in that case. This is that matter where Zitco had filed, finally the state has filed an SLP, Malad.
Yes,
Which is that.
state has filed a SLP, but today may not be the right day, so we'll give you a date.
Malad, may kindly keep it, adjourned on 3 occasions.
3 adjournments earlier.
Malad,
One more adjournment is not going to harm you.
it may be taken up with item
36
90.
and 90, Passover is sought, however, the matter stands adjourned. List on 13th March.
Malad,
13th March.
15.
Next matter.
Item 37.
Oh, counter affidavit was filed in the miscellaneous. They say that they were supposed to declare the self-assessment.
Wrong. At
Self-assessment.
no point of time.
Self-assessment 4%.
Exactly. No, that is according to them. But Malad, we have disclosed. And the reason why we are saying this.
No. They've rejected your self-assessment and you.
Yes,
instituted
and they were aware of it that it's been rejected. They filed an appeal against that. And then they waited for the appeal, file this.
Very. This perhaps we'll take up on another day. May not be possible.
We'll file a rejoinder.
File a rejoinder.
I'll kindly go it on a Tuesday.
Yes.
And finish it out.
Not on a Tuesday, a Wednesday or a Thursday would be better. Tuesdays are also equally. We've got 125
I
matters.
leave it to him. I leave it to him.
So
Well, then
Wednesday or Thursday.
I assume notice is issued.
List on 12th. First week might be a miscellaneous week again. Possibly 19th. 19th March. Rejoinder may be filed in.
Well, it's in the meanwhile, notice is issued, obviously, in this matter. Notice has not been issued as of now.
We can hear you without notice also.
Malas, then at least Malas will condone the delay since it's gone.
Let the rejoinder come.
Ask me not to worry. Oblige, Malas. Oblige.
Item
Lordship.
38.
For short.
But you filed an amended SLP straight away, is it? What is this second set that I received yesterday? You need to. This is SLP which you filed, in which you challenged only the 4th July 2024 order.
Yes, sure.
Therefore, if you want to make changes, you need to file an application for amendment. You can't straight away amend it and then say, I'm filing an amended SLP now.
We have filed an additional application regarding the.
Where is the application for amendment?
I'll vote for record, Lordship. I'll give me a short.
There's no application for amendment.
I myself have given to my clerk on Friday. I'll check it.
There's no mention of it, no application filed for amendment. Permission to file additional documents. What does that mean? Copy of the same miscellaneous document.
Shall get it? Give me a short.
There is no proof.
And counsel for the petitioner seeks an adjournment. Enable him to verify as to what has been done in this month. List on 7th page.
Oblige, Lordship.
My lords, a letter was circulated in this matter.
You don't have a letter. Anyhow, you want an adjournment?
Yes, congrats.
On what ground?
My lord, the arguing counsel is indisposed.
Very good. Adjournment is sought on the ground of ill health of the learned arguing counsel. List on 14th page.
May it please the Lordship. We are challenging the order on 5 grounds, my lord. The first one is complete forgery and fraud with the court. Then, my lord, the second ground is
just one information preliminary submission as a caveat for 3-4 respondents. They were directed to deposit 50%. This court dismissed the SLP. Till date that 50% is not deposited, only 10% is deposited. They still seek stay and suppressing the fact that despite extension of time by the High Court, they have not deposited 50%.
They asked for extension of time.
Yes, from the High Court.
that was pending the disposal of the appeal, my lord. Now the appeal was disposed of.
When was that last order?
My lords may have page P32. My lords, the order dated 18th August 25. Page 1079. This was a case when the High Court granted stay subject to 50%.
That was during the pendency of the appeal. Now appeal has been dismissed. We have come before your lordship subject to whatever order is passed. 10% as per the order of this honorable court has been deposited, my lords.
Well, this was interim 10%.
1079 is our order.
Yes, 107 is my lord's order.
That specially.
Yes, and said
No, the
please.
With respect to it was still pending.
Yes,
Whether it
interim.
is disposed of and they have
Lordship
done
dismissed it.
We'll just give you a date. This much
No.
requires.
5th September, they
Lordship
go
may
for extension 1 month for deposit of
Whatever it is,
50%.
now that it is-
They have not deposited and they come up and they say on the amount deposited, the matter be stayed before this.
We'll consider on the next day.
Lordship will consider the next day, my lord.
Pleadings are complete.
My lord, yes, my lord. I may.
Notice as.
Yes, my lord, I may inform my lord. My lord, one matter is already, my lord, leave granted, my lord, it's pending, my lord.
One of the two issues are pending before your lordship. This honorable court kindly see the order.
Different parties, nothing to do.
No, my lord. They are on reliance on this, my lord. They have got that order, my lord. Kindly see. There are two matters which are
Same
pending.
acquisition?
Sorry.
Same acquisition?
Same land acquisition. No. Separate land
Milord, on the issue of Milord multiplication factor, Milords, the issue is relying on the judgment of Guwahati High Court, against which this SLP is pending after leave granted, Milord. They have taken the order, Milord, in their favor, Milord. That is also under challenge.
So even there's a 50% deposit condition.
That is a different matter, Milord, so far as that deposit. But then, Milord, this, but they have not
notice and ask you to pay 50%.
Milord, case, Milord, it suffers from fraud, Milord. I say, Milord, it's a case where it suffers from complete fraud. Here, Milord, fraud mitigates everything.
An implementation of the implementation.
On the condition.
Oh, on a condition that
they are all not.
Deposit 50%. We'll consider on the next.
Lordships. Because here is a case which suffers from complete fraud, Milords. Therefore, Milord, that is a distinction.
That order which we passed
Lordship
shows that you suppressed something there.
No. Milord, that was one list of date, Milord. One list of date. Because
that doesn't reflect well upon you, does it?
Sorry?
Mr. Sanjay, that didn't reflect well upon you.
I know, Milord. I know.
So let us not say anything about fraud at this stage.
Milord, that I will demonstrate before your Lordship, Milord.
Very
the manner in which
27th February.
27th February. Deeply obliged.
41.
So I'm seeking a password in this matter.
Milord, sir,
in any event, what is there in this matter?
Milord, can that matter be on Wednesday or Thursday, Milord?
27th is perhaps.
Instead of.
Ms. Gupta is gone?
Yes.
Yeah.
Any Wednesday.
On a Wednesday, perhaps might be better. 25th February.
25th. Great.
Great. Mother's next one.
This one over.
Twenty-sixth.
25th.
25th. Great.
Deeply obliged.
Great.
I'm very anxious.
41.
Great, please.
According to you, leave that technical issue. You may have a point there. But your lease is over in 2020.
It is not. That's absolutely incorrect.
Where is the extension after the
No, if your lordship see the receipts, just see page.
Where is the extension?
Yes, I'll just show that.
No, even otherwise, your case is that you are not in possession, your mother is in possession.
My mother is in possession.
So then what is your problem?
Through her hand only.
She is aggrieved, she has to come.
Still alive.
Just see 30.
See, your mother is
If
still
she is
alive.
aggrieved, she has to come. Why has she not come then?
Your mother is alive.
We are not in position.
Have you ever said that anywhere? Your specific contention is that I am not in possession. The mother is in possession. But if the mother feels that her suit could not have been dismissed, she should come here, not you. You should not.
Ground A and B, you said he was never in possession. Mother was at party. You're not inclined to entertain.
My lord, may reserve the liberty for the mother, my lord, at least. Otherwise,
You find no grounds to entertain this special leave petition at the behest of the President.
Yes.
In the light of his clear stand that he was,
Lord, may I make one submission, my lord?
he was never in possession of the lease land. The special leave petitions according to this.
My lord, may I just make one submission, my lord? I am just informed the mother is also filed in SLP, my lord. This may be taken up in that one.
No, we've already said that at the behest of you. Dismissed at the behest of you.
Very well. Well,
43.
43.
Yes. Respondent was.
What happened before the
So it was heard on 14, 15, 16. Today it's kept for rejoinder conclusion at 2 p.m.
My lord, I appear
the orders.
appellant.
Nothing.
My lords may have it after 1 week. It's kept today for rejoinder arguments.
We are informed that the NCLAT is presently seized of the matter, taking up the matter today.
Yes, can I just today 2 p.m. The counsel for the respondent wasn't available on the last date.
Lord, can I just say something, Lord?
Yes.
I appear for the respondent. Lord, we've argued this matter for 3 days. Due to a health issue on our side, the matter has to be only kept today for 15 minutes. So, my Lord, my request is if my learned friends are keeping this appeal alive, then my Lordship may have it after 10 to 14 days because today it will be reserved. I myself made the submission before NCLAT that please reserve it. We are filing written submissions also today.
20th March.
Grateful.
Obliged, my lords.
Wait.
Item 44.
Wait, please, my lords.
Yes.
Just take this 2 points is better put here. Kindly turn in this note to page. Sorry, give a copy immediately. To page.
One moment, Doctor.
3 minutes.
1 moment.
Where is that? Just turn to page 3 of this note. I'll only read a few paragraphs, not. It is para 1A. Take third line. There was no prayer, the specific prayer seeking recovery of possession of any quantified built-up area. My lords can check 155 of the claim. Don't need to go there. I put the page. There is no specific prayer. Now look at this B malas. The award declined these 2 malas basic prayers. The award against me declined these 2 prayers. Next para. 1, cancellation of JDAs declined and declare sale deed null and void declined. Then did Malas complete rewriting on an ad hoc basis saying, in lieu thereof, a direction for recovery of possession of the owner's entire super built-up area, para 91, page 261, with no Malas, this is a rewrite, there is no such contract of any kind. Then Malas, section 34 court in my favor. I am today in a reversal order. Malas, 37 reversed my 34 in my favor. Held that when no relief is prayed for, the tribunal wrongly granted relief not pleaded, proved or prayed and further dealt with the consequential directions. So this is my favor. Now ignore D, come to E. Come to E. Cancellation of JDAs and sale deed and a direction for delivery of possession of specific built-up area is justified by the impugned order by saying it's a lesser relief. There can't be a lesser relief. The 2 are distinct executable decretal orders. The High Court's approach effectively grants an unplayed relief by labeling it as a lesser relief, which dilutes the permissible statutory limits of arbitral jurisdiction and McDermott. Your Lordship doesn't allow rewriting in this. Now, 3 pointers. The second point is then I come to the third one. In the second one, para 2A. Now, this is the first part, that there was no specific prayer seeking damages. That's repeated. That's repeated. Now, come to 2B. Yet the arbitrator at para 62, page 195, gives damages of 83 crores. That's crores, 83.96 is crores. And continuing monthly payments of 89 per month. The 34 court in my favor at para 12 found this reasoning of the arbitrator to be in gross violation of the terms of the agreement. At para 16, that is the 34 court, it notes that based on a government order of 1996, which is at page 68 to 69, the noting, the petitioner could have started construction without waiting for sanctioned plans. Could not have. Could not have, right? Yeah. That's a misprint.
Could have started.
Oh, sorry, could have. Could have. I'm sorry, but it's could have. The section 34 holds that question of liability arises only upon completion. Now, this point is important for my third point, which is the date. The date is wrongly taken, but there are 3 dates. Bhumi Pujan, date of construction start, or date of sanction of plans. They take Bhumi Pujan the earliest, whereas the latest had to be taken. In any case, I have got sanction plan date. So you have to take it, that's coming in the next point. Just give me a minute. The Honorable High Court in D. has observed in para 24 that the arbitrators balance the situation. What the 37 reversal is basically based on broad, equitable ad hoc approaches. Now come to 3 Malas. This is very, 2.1. 2.1 does my Lord have?
Yes.
This is a very important point. I am assuming without conceding the damages are payable. No pleading, no Malas is approved, but I am assuming. Now this is important, Malas 2.1. Even then, the date has to be 28/10 and not 1/11. Why, Malas? 28/10 is the date of sanction plan. I hope I'm clear with this.
Yes.
Now come to A. All 3 JDAs clearly say in 8H, page is given 97, that for the period of completion of construction shall be 24 months from Bhumi Pujan, or date when construction actually commences, or date of receiving plans, whichever is later. In a specific question in the cross, when asked, the other side witness in the middle of that para at page 187 at para 50 admits that the period of construction for the period shall be completed from any of the above 3 dates, whichever is later. 8K says that if construction is not complete in 24 months, the developer will have an additional 6 months to complete construction, during which they will get compensation of 15 rupees per square month. Before 6 months, the JDA to stand automatically terminated. 10E says that from the date of completion, the developer has 6 months, etc. I'll skip that. Now, here the sanctioned plan date is 28/10/11. Yet, let us come to B at page 5B. Yet at para 50, page 187, the arbitrator accepts Bhumi Pujan date, that is 2006. That is 5 years earlier. 5 years earlier. As the date from which the 24-month period would commence. Even though admittedly the sanctioned building plans were received only in November 2011. That's a typo. That's 20th October, not 20th November. It should be 1 month early. It doesn't make a difference because I have been given an award of 2006. The starting point is 20th October 11, not 20th November. Well, your Lordship gets a 3-year hiatus, so the damages will then start from 2014. Just give me a minute on that. This the arbitrator does only on the limited point that R1 had stated in an old communication that though the contract provided exactly as what is being said, it may not be correct morally. Let's kindly see this. 2006 given on the ground that 11 may not be morally correct date. If 11 is the date, then damages have to be computed from 2014. I hope I'm clear with this. It has to start from 2014. Yet the arbitrator takes the moral standpoint as to the basis to treat Bhumi Pujan. Now, damages for loss of rent from 11 to 21 is 83, continuing monthly payments. Then we'll ignore C, come to D. The section 34 court holds that the question of liability for rent arises only upon completion of building and the grant of damages, and that too beyond the contractual period of 8 years is erroneous. Despite this, the High Court in my impugned order of 37 Malas has observed at para 19 that the arbitrator is correct in adopting the moralistic argument contrary to the written JDA as well. And then F, the impugned order upholds the arbitrator's view fixing October 11 as the only view. It will be perverse to reckon completion times from the later sanction plan date if that ignores the actual completion admissions. It further relies on post-contractual emails to find that parties are given a go-by to the contractual stipulation. Well, this requires consideration. This is written totally as if it's some kind of a equitable order.
But you wrote to them saying that you would start paying rent from April 2009 itself. You wrote to them. There's a letter. It's not just a question of you saying that it's morally wrong.
No, just see. Partly answered in G. It's incorrect because firstly, first of all, contractual clause 28/10, the sanction plan date has to be treated. G.
This letter which is referred to, where is that?
Yes, we just show the letter. 2009 letter. Go to the page.
189 reproduced.
It's the real count is 189.
12th January 2009.
At 189, actual letter. Where is the actual letter? It's mentioned at 189. Not here? Well, let's just come to 189. It's partly quoted. In fact, all the relevant part is quoted. In paragraph
12th January 2009.
yes, at paragraph 53, Malas. The first prerequisite before the property could be tenanted is answer it. Building could have been complete to the extent possible to move in with such mind. The first communication that is available in 2009 under Exhibit 21, in which they expresses gratitude.
We shall start getting rent from 1/4. What does that mean?
We have finally concluded with the client. I shall send you the agreement early next year.
So that is with regard to some tenant or someone, is it?
Yes. We shall start getting rent from 149. That never happened. We never started getting rent from 1409.
See, how do you say that when your sanction plan was not there at that time?
Yes.
They started construction. They started construction.
Sanction plan came only in 2011.
Geo was permitted them to start. You started construction in 2009 itself.
10 or 9?
9.
Yes. Before 9.
Before 2009.
6 itself.
6.
We started construction.
6 itself.
Yes. Now let's just see G.
They have interested tenants.
1G.
When did you allow occupants into the building without a sanction plan itself? How will you do that?
When did you allow occupants? Only 17.
This is in Chennai.
Only 17.
Then why don't you take this undertaking? That
Coimbatore.
Coimbatore. But
Only
the same
17.
laws would apply because I dealt with that Madras property
No, I
matter.
got query about occupation.
Perhaps you appeared in that Madras property matter. The Madras property, Lancor Holdings.
Ah, yes.
You appeared.
Yes.
So you could not get water and electricity without an occupant.
No, therefore the occupation is 2017, Manas, admittedly. Occupation
why do you say that we shall
get rent
from
from
that
2009?
Because it never happened. It's a tentative communication of 9. Can't go right the contract. The fact never happened. I understand, but it's a
But what
casual
exactly does that
good time.
letter? This is some email that you're
Yeah,
referring.
but this is a good time. Well, we will not.
No, but 12th January 2009 letter, what did you say?
This only, well, that we will get rent from.
This is your email, perhaps.
So this quoted, well, that thing quoted
There are
below is
two
that.
things there. You seem to have sent an email as
This
well
is
as the
same.
letter.
Huh? So this letter which you'll also be asking is quoted in para 53. 12 January is quoted. It's in the email.
There seems to be an email dated 24th December 2008, followed by a letter dated 12th January 2009.
2008 we don't have here, but just
So-
check up. Just check up.
This
This is
extract,
the-
is it from the email or from the letter?
This is from 12 January, Malas.
This is from the
12th
12th January.
Yes. Well, just see my note, para G. These are the 3 legal grounds, Malas, which arise on the date. Firstly, 28/11.
Does the High Court infer that there's a novation of the contract?
No.
on
It says, the High Court in 37 says simple. The arbitrator did a moralistic conclusion.
Uses
That
that
moralistic-
word also?
Yes, please come to that. That's very important. Come to para B on the same page 5.
No,
That's
in
my problem.
the body of the judgment, where does he say?
Yes.
The division bench, where does it say that?
This correct morally.
Moralistic.
Very not correct. Which page?
Moralistic and
I did. In the arbitrator's award, it is there. Malas. That's all.
you said that the division bench has also upheld that.
Division
By
bench
using the
says-
word moralistic.
Division bench says that upholding this, we are not wrong. The arbitrator took that stand. First, see, Malas, page.
There's only a
49.
reference to what you yourself said that it is
First,
not
the
correct
arbitrator award.
morally.
First, let me show the arbitrator, and 49 is the division bench. 49 is the division bench, show the arbitrator's award.
49 only says that when the arbitrator has balanced
The
the
division on that ground, but I must take out the arbitrator's award. 187 is the arbitrator's award. Arbitrator's award. Just come to that. You also will get the context then.
Unless he says this is 7.
Yes, just come to that. Give me that 11 line. No, please give me the work. Moral correctly.
Let's see. When did the construction commence? Soon after Bhumi Puja.
Further, as per agreement, my commitment legally. We have not yet got the full sanction officially. So most of the cases, I can hide behind this, but it is not correct morally. This is my witness saying this. Turn the page, Wallace. Now the learned judge in the division bench says at page 49. Page 49. This is very long here. At page 49.
Yes.
49 million.
Did they get a multi-story approval in 2008?
No.
Middle of 49. You're taking a broad equitable to the middle of 49.
What do you call?
49. Hello,
Yes.
49.
Did you have an initial approval of a plan and thereafter a final approval?
What is this about a multi-story approval?
Well, we need to have approval to generally start. The sanction plan comes in 11.
2011. That's the final sanction plan.
That is the sanction.
But
So
you
need
had an
permission to
initial
start.
sanction plan.
No, well, we need permission to start. We need to file papers. I mean, those papers we can file in a compilation.
You don't have to have a sanction plan to start construction.
Well, apparently
That
not,
GO
because
that
apparently
GO
not. I mean,
seems
I find it in Delhi, certainly not. In certainly for IT parks, I'm told there is an exemption. I can put those papers on record. That GO of 96
permits you to start
for
construction.
an IT park exception. Even then, well, there have to be papers, but maybe not a sanction plan. I mean, I'll need to get
What
those.
papers would you need?
No, I'll need to file all the my architect's plan. I'll need to file.
Setbacks need to be maintained.
No, I'll need to file
Whatever
an
you do
architect's plan.
internally is
Yes.
one thing.
You don't need a prior sanction is all that may mean. It may mean.
For a IT
park, this is what they are saying, but I need to, we've got those papers in the arbitral award. Just see this 49, the approach is, I'm on the approach,
Yes.
See page 49. This is 49 and 45. Why are you? 45. Why do you change? Now, first of all, the morally correct part. My problem was I was a bit too honest. I started talking of morality in my witness box. It's okay, but that can't be the basis of an award. 45. Turning to the email of the developer of 2008 and 9, although they treat 12 January also as an email, it is obviously clear that the developer has conceded that taking cover under the expression whichever is later is not correct morally. I don't know why my man said so.
execution proceedings have been initiated.
Just come to
Yes, please.
yes.
You have.
Yes.
Yeah, we have.
Yes or no? We haven't got notice.
We haven't not got notice, but they will know better.
Just see page 16.
60.
16.
Yes.
Well, can I just 5 seconds? 45. Just see for a minute. To connect this, I'll come to that immediately. It is obvious third line that the developer, that is me, has conceded that taking cover under the whichever is later, which is contractual, is not morally correct, and he will see to it that rent starts coming from 9. That's a letter which never got acted upon. Now, on this C49, page 49, he gives a finding saying the arbitrator is not wrong in following this. Middle of 49. When the arbitrator has balanced the situation, taking into consideration the overall facts, granting the lesser relief than the relief sought, the same cannot be taken. This is the approach. It's done on a very mediation basis.
This is correct. 8-7%.
16 or 16?
No, but have you seen 19?
16 is.
As per the claimants, the date of multi-story building plan approval is the date of commencement of construction.
Same one.
So then you commence.
This is the contention part. This is contention. Let me read that. As per the claimant, the date of multi-story plan approval of 18th of July is the date of commencement of the construction. The 24 months time to complete the construction ends before 2010. According to developer, the date of completion is record. But obviously not, because the contract says Bhumi Pujan, sanction or construction.
What is the nature of this approval? It's not a sanction plan.
No, it is certainly not a sanction plan.
But
because it is common ground that it came in October 2011.
But you obviously started construction even before that.
Well, is that I'm told, but either Lord should allow me to file the second volume, because I don't want to. That IT parks don't need a prior sanction, which I don't know about. I'll have to file those papers.
So again, the sanction plan has no validity if it doesn't need a
Mainly IT parks must be giving the
sanction plan is not required for construction or for inducting tenants. And as far as they are concerned, they are only concerned with the construction and the
induction of tenant happened in 2017. You can't induct.
One, There are definitely debatable points.
Because I'm going to request
because the arbitrator has rewritten the contract.
Because I'm going to
To what
request
extent that was permissible given the fact situation in this case, perhaps we'll need to examine it.
Because I'm going to.
But there are at least issues that need to be looked at.
All right. So can I just respond? I'm requesting you with folded hands. Please don't touch this and just listen to the facts. The arbitral tribunal has described this as diabolic, what he has done. Now just listen to why they said so. My agreements are of 2006 and 2007. I gave 8 acres of land to this developer. He was to give me 20, the consideration is primarily in kind. Some small amount of 1.6 crores was given at the time of execution. And
you get 20.
Now just, can you imagine, from 2006, 2007 onwards, I have not received a brass farthing and I have not received a single square foot of area. Now just have a look at this, please. Just have a look at this. Give it to them. Come on. Number 1. Yeah. Oh, give it to me, driver.
Couldn't you have made them a little smaller?
Yeah,
so that they would fit into the 5.
That's to impress your lordship.
These are the
towers. Now, just a second. Now, I'm just going to explain to you. These are the 2 towers which are up. It's the IT park which is up, right? He has to give me a little less than 2 lakh square feet of this tower. He has to give it to me. 20% of my entitlement. He identifies, and I'm going to show that to you before the arbitral tribunal. He acknowledges that yes, I have to give the whole of Tower C, which I have marked, and a little portion of Tower D. He has till date not given, on the front, on the very first, we've written C and D.
C and D.
The whole of C is to come to me. The whole of D, a portion of D is to come to me. He acknowledges that. He has till date not given it to me.
Get 20% only.
Yes, 20%, because it's out of the 8 acres of land and developed area. But this is not.
How many more would be coming up?
So that he may construct more, but that's a separate. Now, just let me just go step by step. He has inducted. You will see on one of the pages. The idea is to sort of put counsel at a disadvantage. So I don't have a copy of what is handed over. But anyway, the point here is that they have inducted. Your lordships will see. Just see the 4th page. I believe it should be on the 4th page. They have inducted all these people and are gaining a revenue stream. For the first, your lordship is seeing. So he's got this continuous revenue stream for this. He hasn't parted with 1 brass farthing. Though, so this area is for me. He has inducted tenants and is earning a revenue stream. Not 1 rupee being given to me. Now, please, and now I'll develop the point. Now go to page 200, please, of the arbitral award. And what the arbitrator says is, it's a waste of national assets. If I have to, you are in breach. It's a waste of national asset. I'm not going to allow these buildings to come down and be torn down. And therefore, he records their submission. Now go to 200. Issue 16 and 17.
No,
a case of, your lordship has that?
We need clarity on one issue.
Yes, of course.
How many buildings are to come up on this 8 acres?
That is on the basis of, that's on the basis of built up, sorry?
As per your MOU.
Yes, so therefore more buildings can come up. Please just see the 3rd sheet is this particular, the open area.
Yes.
Which shows the entire area. There are patches which are still open, where construction can come up.
Very good.
Right? Now just go to page 200.
No, but where do you get it that he promised 20% of these 2 towers which have already come up?
Yes, that 200. Just go to 200. Page 200. Now this is the arbitral award. Your lordship has issue 16 and 17.
Yes.
You will find it very rare that, at least in my experience, it rarely happens. A case of diabolic fraud by the respondents, but will still retain the benefit of the purchase as a measure of exigency, the several circumstances. Your lordship has that.
Yes.
Now, please go to about 7 or 8 lines on that first paragraph 66.
Yes.
If the relief of setting aside the same is not given, it is only on account of the fact that it is inexigent to do so. 2 towers have been erected at considerable cost and labor. It will be a vast waste of national resources if the built-in labor is negated. By setting aside the JDAs, any bilateral document such as JDAs can be set aside only if there had been a vitiating circumstance. I can say that it was surely an unhealthy bargain for the claimants when they parted with 80% of the land and securing a mere 20% of construction that was assured by the FSI admissible. The conduct of RW1 and the council has been brazenly defined and unfortunately exceedingly unfair. The respondents who obtained the benefit of 80% of the land for a consideration of construction promised to be made and delivered has admittedly not delivered the property. The promise to deliver has been moonshine, and even a straightforward answer by RW1 admitting his liability to deliver possession of the property in evidence to my question has not been accompanied by any action to bring the value to promise. I shall reproduce the response to my question during the course of cross-examination on 26th August 2001. Question from the arbitrator. Are you prepared to deliver up Tower D and a portion of Tower C, which you claim to have earmarked for owner's share, and file a memo to that effect even tomorrow? Yes, I am prepared to do so without prejudice to the rights and contentions of the parties. He says this. Now see, the counsel for the respondent would not allow the admission to come to fruition. After witness evidence was concluded, and when I was drawing up the minutes on 26th August 2021, the counsel dithered and said that he would take some advice from his senior counsel to carry out the offer to deliver possession. He changed his stance and said through an affidavit that of the party that there are several obligations to be performed by the claimants, such as sharing of expenses incurred by the respondent number 1 to make it habitable. I said that whatever expenses have been incurred should be adjusted against the rents because the rent stream has begun. At the time of arguments, he had another new contention to make that I had exceeded my jurisdiction in asking questions to the witness about the surrender of possession, and that if only the claimant was given up all the claims against the respondent, he can deliver possession. Yet another fanciful contention was that the sale deed did not contain 80% land and there is a shortfall of 16 cents. This is a contention which has no support in the pleadings. At all times, the claim statement and in the recital in the documents themselves, the respondent had secured through these documents aggregate of 80% of the whole. Now please go to para 66. Unfortunately, till date, the respondents have not even given the plan for the construction made to identify the extent as 69. My mistake. Okay, I'll read 68. If all these actions, it can be seen that the respondents were not prepared to go so far as to state that they were not able to surrender possession because that would have meant failure of consideration for the sale obtained under Exhibit C8, 9 and 10. Here is a case of the respondents adopting a dog in the manger policy. Surely would not let go of all the property which he recognizes as the claimants and not to forsake the claim of 80% share. Unfortunately, till date, the respondents have not given the plan for the construction made to identify the extent as actually available. I will find that the respondents are bound to deliver to the claimants so-and-so square feet from Tower C and Tower D. I attempted to secure the details, etc. through documentary collaboration, etc. Now, let's just pause here for a moment. So just see 2-3 things. What has the arbitrator eventually done? He said that, yes, they had asked for termination. This party is in breach, etc. But there's a national asset over here. Your lordships have seen the photographs. So I am not going to do that. He has recorded a statement saying of the developer saying that I'm willing to give the whole of Tower C and D. So what they do eventually is, just see this. You have put up this and you have recognized that this property is to come. I am entitled to 20% of the completed area. You have inducted third parties. Now just note one thing. The revenue stream for those 8 years is to come to me for the first 8 years. So he inducts third parties and he gets that revenue from those third parties and he doesn't give it to me. My obligation was to share.
What do you mean you need to get it?
I'll tell you what, because this was IT. Let me just tell you, this was an IT park. So I had the land, but I didn't have the wherewithal to identify persons who would come in. So therefore, the arrangement between the parties was that for the first 8 years, they would identify people who are in the IT sector who need 2 floors, 3 floors, whatever it is. So he's brought them in. So just imagine, he's got 8 acres of my land. He has getting this revenue stream. He has not given anything by way of consideration till this late date of, till this point of time. Now, just 2006, 2007 are my agreements, my lords. So the arbitrator, I'll take you to the arbitrator's final deposition. But just note that the first respondent is 93 years of age. Second and third respondents, who are the owners of the land, are 70 and 73 years of age. Now just see what the arbitrator, after getting into this, just see the fair relief which has eventually been passed. Just have a look, please, at page 216. The question I ask myself is, why interfere in this? Please look at 6. Please do. Because the principle, my lords, your lordship's principle is that, look, even if a pleading is not there, if the parties knew exactly what was at stake and arranged it before the arbitrator, they contested the case on that basis, there's no question of some technicality, no prayer, no this, no that. Now, please see, in the result, the relief setting aside the sales and cancellation of JDAs is declined, and in lieu thereof, the claimants are granted the relief of recovery of possession of whatever, so-and-so square feet of built-up area as corresponding to 2.67 FSI within the under-mentioned property. This shall come from Tower D in full, which is said to be so-and-so, and the balance will come from Tower C. Along with this shall be the entire car park of Tower D and the place earmarked for in Tower C that will be proportionate to the built-up area to the claimant. The damages for the period immediately prior of 6 months immediately on completion of 24 months from 1st November 2008 is declined. The relief of damages for loss of rent for the claimants 1 to 3 shall be from 1st November 2011 till October 2021 for a sum of so-and-so, which is the aggregate amount payable as calculated as per paragraph 65 of the order. The respondent shall be liable to pay the claimant for each month commencing from 1st November 2021 an amount of rupees so-and-so till the date of delivery of possession of the property. The amount determined as payable to the claimant shall be apportioned amongst themselves. The amounts determined shall constitute a charge over 80% of the property of the respondents that have to be transferred through Exhibit C8 to C10 in the schedule below in priority of the mortgage created in favor of LIC housing. The claim of damages for the capital gain notice received by claimants 1 to 3 is declined, subject, however, to any amount in excess of the amounts, etc. The respondents are restrained from selling their property without performing their obligations under the joint development agreement. The respondents are liable for the amount determined to pay at 15%, pay interest at 15% per annum. The claimant are entitled to a cost of arbitration of so-and-so. Now, my lords, there are certain other segments of this particular order, which of the arbitral award, which I would also like to place. Yes, sorry, FN? Yes. Yes, so F and G, my lords, will not be eventually, because the High Court has not allowed those two portions of the directions. So that legal issue doesn't really remain. Now, my lords, just have a look. Please have a look at 2-3 other elements. Please just, there was a question which the court had put. Just go straight away to page 1. Sorry.
See, F is declined only to the extent of the mortgage being subject to the charge here. The loan was cleared. The loan was cleared to the LIC before that was cleared.
They have created a charge.
No, that was cleared earlier. LIC's loan was cleared. That was
yes.
That is why the High Court said that.
Yeah.
That is not there. But then the charge remains with you even then, is it not? F remains.
The priority, my lords, in payment, repayment will remain with us. But, my lords, I'm just asking myself, my lords, when people part with land in two, now whatever the bargain was originally, when you have 2 towers which have come up like this and the gentleman has given me nothing.
Buildings completed?
These buildings, my lords, have been completed at least.
Quite a while by the looks of the nameplates at page 4.
17 months, 2017.
And since then, you've not given them anything.
Anything at all?
Immediately. Answer prejudice.
Yes or no?
Yes.
Have you given them anything?
I have approached them 3 times. He filed criminal cases against me from 11.
You approached them with what?
No, refused to criminal cases against me, refused to settle. They are all quashed in my favor. I have offered in now, the building.
You made a statement before the arbitrator.
Yes, that is later. Give me 2 minutes. It'll solve the problem. He is entitled under clause 20%. He admits at page 109 is the clause. That translates to 1,95,000 square feet. I'll give it within 1 month. Number 1, prejudice. Prejudice number 2. I received the first brass farthing to use my reference language of rent in 2017. He was hot-footing my criminal cases. I tried to mediate with him. I will bill him the entire rent from then 2017 till today of his share with interest in 4 weeks. That's the
How much is that?
whatever is the amount.
No, you tell us what the figure is.
It's about 20 crores. It's not a small amount.
You are supposed to pay him now 83 crores.
Therefore, Malas,
83
my
crores.
payment is for 17 to today with interest I will pay. With prejudice I am saying.
Someone who has parted with 8 acres of land.
How? Why did you pay 8 acres? You will get a loan. Justice Chandran's question, I will have paid the loan, released the charge of LIC.
That's the different thing.
That's the reason he came to me.
See, that's a different thing altogether. You have to release the charge.
Today,
otherwise the priority would have been.
May I say one thing? Prejudice cannot take the place of law. Page 98, the clause is whichever is later. Page 98, the clause is whichever is later.
They are entitled to interest.
The two clauses that he has is all rent due to him with interest from 17 over 20 crores he will get. He will get 1 lakh feet, which is ready from rental only.
If this building was complete, I mean, to just test your bona fides.
Yes.
Even if you thought he was entitled to a portion of this building, that 20% of this building and this other building, you ought to have offered him.
No, there was 20. That's my witness offered.
Never did that.
My witness offered.
Where? He said that he would take the entire building.
No, he offered, he read it.
He said the entire Tower D and a part of.
Yes, it has to come to me, my lord. That is the
So even if you made that statement, you didn't want to stand by it.
No,
at least 20% of each building you ought to have offered.
21 till now, the relations have been so bad, they're filing criminal case. That's why it happened today, Malus. Your lordship is silent of the matter. The building is entirely his maximum claim, according to him, is clause 2B at page 109. Which is 20% of this buildings, he can have it in 4 weeks from today. 4 weeks from today. His entire claim is 20 crores plus interest. He can have it now.
In some cases, perhaps we have to look beyond the legal point.
The law should not allow an unjust order contrary to law to stand because of equity and prejudice. Just because the arbitrator is
4 years.
Just because the arbitrator is prejudiced, because of these facts, your lordship will not allow prejudice to stand in the way of fact. The clause at 98 says whichever is later.
Look at the facts also sometimes. Law can't stand.
Well, that is based on
the injustice that is
both.
You have been completely unjust.
Because he gets full 98, full balance within 4 weeks.
Completely unjust.
With interest.
Nothing.
Obliged.
What happened to this matter?
Lord, here the High Court has kept it on the 29th.
29th.
Your lordships could keep it in the middle of February.
We are informed that the High Court is seized of the matter and has adjourned it to 29 January. List on 10th March.
I'm waiting for the orders. Why did the High Court do it? They deposited the money.
46, Lordship, give me some accommodation. Lordship, I got an injury.
Sorry, 46, is it?
Lordship, I'm for the state. Lordship, give me some short accommodation. I got an injury.
As per the office report, the High Court records are received, the trial court records are not received.
Yes. Not received.
Whatever that means. You'll need the trial court records.
Yes, the trial court records. Because there is a letter circulated by the counsel for the respondent.
Registry is directed to follow up with the follow-up and requisition the trial court records at the earliest. You've already received the High Court.
High Court order is here. On 17th, Lord, I have received this month.
List on.
Trial court.
We'll take it up on a Wednesday.
Please.
8th April.
Much obliged. Much obliged.
Please.
47. Only the IA is listed.
Lordship, seeking accommodation, Lordship, learned senior counsel is not well today. So any next
Adjournment is sought on the ground that the learned arguing counsel is indisposed today. List on 27th February.
Lordship, next week if it is possible. Lordship,
You've been inside for 1 year and odd.
I was.
So even according to para 13 of your suspension of sentence application, 4 years sentence is adequate. So once you said that, at least remain there for 4 years. Then.
Additional spike is ailing your lordship.
That doesn't mean that
next week, your lordship.
you've already been let off lightly. The sentence is reduced, is it not?
No, High Court said.
No, Your Lordship, I was
Oh, I see. This is 302. Earlier was 4. Earlier was 4 years. Now it's 302. 302.
Any earlier.
27.
In this, may I seek permission to serve the complainant through the SHO Manoj? He has appeared in the High Court. The address of
taken though.
No, please. What happened, Manoj? I've given 2 different addresses. I've tried substituted service.
According to the office report, since the last date, you have not taken any steps at all.
I have not been able to trace him at all, Manoj. May I only place the facts, Manoj? This honorable court gave me 2 opportunities. I gave fresh particulars. I also effected substituted service.
I will learn counsel for the petitioner, seek some more time to effect service of notice upon respond number 2.
Manoj, may say through the SHO, Manoj, because the same address, he appeared in the High Court. Here he's not appearing, Manoj. I'm only saying with the help of the state, Manoj. Otherwise,
we'll serve it through the SHO.
Such service may also be effected through the jurisdictional police station.
I'm deeply obliged, Manoj.
Item 49. The Lordships are being led by the London ASG is caught up in court number 5, but either ways the trial court records were requested.
The service is also not complete in the test office report.
Service is incomplete.
On respondents 1 and 3.
As per the office report, I don't have the office report. Just mention that. As per the office report, service is still incomplete.
Office report.
Steps shall be taken to complete service of notice upon the unserved respondents. What about counters?
It has to be. You have to find counter.
You are for?
Number 2, I am
R2. You had asked for time earlier?
Yes, my lord. We had asked for time.
Learn counsel for respond number 2. Seek some more time to file a counter appeal. Usual order. List on. Sorry?
Original record has not done.
Original trial court registry is directed to follow up with the trial court and requisition the records. With regard to that also. And list on 25th.
Lordships may please mark the ASG's presence.
Without the ASG being present, the ASG's presence will not be marked. Your presence will be marked if you get anything out of it.
Highly obliged. Thank you.
Item 50.
In item
50.
Item 50 on the previous occasion, your lords were pleased to permit us to bring on record information about the legal heirs of the one deceased person. We have now filed an IA to bring on record that information.
Only one?
The IA is 3153.
How many persons died?
Only one person.
Only one person died. So these are the
Yes, ma'am.
Issue note IA number 315386 of 2025. Issue notice to the
Madam, I have a submission to make, if I may be heard. Instead of including each of these legal heirs, my suggestion is that the amount can be deposited in the trial court.
Without hearing them, where is the question?
My lords, if I may just pass on an order.
How many are there?
There are totally 8 heirs.
Very well, let them come forward.
My lords, if I can just pass on one order. Whether
it can't be behind their back. Where is the question?
In a similar case, that was the thing.
Well, that is not the procedure I would like to follow.
The reason is that
that's not a binding procedure. List on 7th.
Item 51.
My lords, in item 51, I beg to appear on behalf of respondent number 224. My lords, I am praying for a week's time to file counter.
You entered appearance? Not yet.
My lord, I have entered.
You filed your wakalat?
Wakalat number is there.
And counsel appearing for respondent numbers 2 to 4. Takes time to file a counter. Usual order after that. List on 24th March.
Well, the state's counter is on record, Madam.
Counter affidavit filed by the state is taken on record. Rejoinder thereto, if any, may be filed by the magistrate if there. 52.
52, I appeal for respondent 1 and 2.
Are you interested in
limited
notice for settlement? We'll go before the mediation.
Can we make some arrangement? I have discussed with my learned friend. If this matter meanwhile can be sent to mediation, lords.
You want to go for mediation?
Item 50, lords.
Very good. Mediation, that one also. That R224 counter affidavit in the event mediation fails there. Then appear before the mediator on 5th February.
Grateful.
Then item 52 also appear before the mediator on 6th February.
Grateful, my lord. Deeply obliged.
No counter affidavit,
My lord, not required.
not required.
2 weeks sentence imposed, my lord, 10 days undergone, my lord, may leave him on the
Exemption from surrendering already granted.
leave him on the under. 2 weeks is the sentence under 320.
Cast abuse, attacked with a sword, is it?
No, not so. It's spade.
Spade.
They were it's in the field, agricultural field, the dispute took place.
Very.
My lords, only one submission, my lords. Compensation was ordered, my lords. He is one for 1 lakh, my lords. He is only for my lords. There is no my lords.
Compensation payable to the victim.
Yes, my lords.
There is a question of setting aside that without the victim being before us.
No. My lords, already fine was granted, my lords. 1,000 rupees has been imposed.
Compensation we cannot set aside in the
Time is
of the victim.
357, my lords.
If it doesn't go benefit.
357. CRPC 357, my lords. Compensation.
In any event, we can't.
Only if there is no fine, my lords, then compensation.
We cannot touch it in the absence of the victim before us. Please understand that.
We may implement that.
We may implement them. And counsel for the petitioner seeks time to implead the victim who has been granted compensation. Steps in that regard shall be taken within 2 weeks. List on 4 weeks. 4 weeks list on.
He's not on bail.
His exemption is on 6th April. Exemption from surrendering granted earlier. Will stand extended to the.
They suggest, my lords, we are ready to pay 25,000, my lords.
We already told you we can't change anything in the absence of the victim.
Keep them.
54.
Not pass on.
No pass overs today. Yes.
3 weeks time to file a counter.
Very good. Then counsel appearing for the state of Tamil Nadu seeks time to file a counter affidavit. Usual order list on 6th April, 7th April.
My lord, I am seeking more 2 weeks time.
In
As
55.
55 lords. As
Counter.
students are residing in different cities, and I just got Vakalatnama on behalf of cancer patient respondent number 3.
You are appearing for which?
All respondents.
All the respondents. And counsel appearing for the respondents seeks time to file a counter affidavit. Usual order 7th April.
So great.
Item 56. Was any fixed date, notes?
7th April.
So great.
56, there's a letter.
My request.
Adjournment is sought by the learned counsel for respondent number 2 by way of a letter to enable her to file a counter affidavit. Needful in that regard shall be done within 3 weeks. Rejoinder thereto, if any, within 2 weeks thereafter. List on 17th.
My lords, I appear for the state, my lords. Likewise, the same order, my lords, filing counter, my lords.
Respondent number 1 is it?
1, my lords. State of
counsel for respondent number 1 is also makes a similar request. May file this counter affidavit. Same here.
Great. My lord, there is a letter from the private respondent.
You don't have a letter
for adjournment.
No letter?
No minutes.
And it seems to have been communicated to him.
Minutes.
Which respondent?
Minutes. I'm instructed that there was the letter was not accepted by the registry. There was a letter circulated, but it was not accepted.
On what ground?
Not filing the counter affidavit.
Which respondent?
I'm for respondent number 2, Milots.
You need to file a counter.
The state, I believe, also needs.
So,
Milots, I just one small submission to make, Milots. On the last occasion, my lords had directed him to produce the original sale deed of
1965.
1690.
That is with us, my lord. That is with us. We can produce it right now.
So that we could incorporate our response in the counter affidavit.
Will you be?
If they are producing it.
Will you furnish a copy to them?
No, it was to be produced before the
original. Yes.
Yes.
I'm not asking you to give the original to them.
No.
Furnish a copy to them.
Just now we will give you.
Very. So I do not remember now in what context I asked for the original.
There
was an issue of forced sign, my lord. That's why.
How will we know?
Your lordship may.
That's what I was just coming to that next
my
submission, Milots, was that there is a civil title suit filed before the learned trial court. Till date, they have not produced this there. This actually requires adjudication in the title suit in the trial court.
They let them produce this there as well so that the proceedings there can go on. Because of this one point that they have not produced this, my learned friend would give me just 1 minute to make my submission. But if this
A lot of stress was made on the last occasion, Lord. I just explained under what context your Lordship had directed it to be produced. My Lord, they were insisting that we do not have the original sale deed of 1965. And that was the reason your Lordship asked that, all right, in the end, your Lordship will find, your Lordship said that, all right, you produce it on the
falling from what my learned friend is saying.
Now I recall, that was the statement, that we don't have the original.
It's been 2 years since the title suit has been filed. Till date, they have not produced this.
Now they produced it.
Now they produced it before this honorable court on the direction of this honorable court.
1565.
So let them file it there so that that suit can proceed as well.
Original sale deed dated 1965 is produced and perused. The same is returned to the Learned Counsel for the petitioners. Copies of the said sale deed may be furnished to the Learned Counsel for respondent number 2.
Yes,
You also want it? For
I'm just
respondent
giving
number 1
copy,
and counsel for respondent.
I'm just
Counters may be filed by the said respondents within 3 weeks. Rejoinders thereto, if any, may be.
May I also seek this indulgence?
List on 20th April.
May I
Earlier interim order dated 10/11/2025 shall continue to operate till the next.
I just want indulgence and let them place the direction be given to them to place this, whatever it is.
You can produce this before the trial court.
But this is not the original.
That's not the original.
This is the Xerox copy, madam.
The Xerox copy given to you.
I do so.
We have mentioned that the original is produced, so you can
My
ask.
only concern is because what has happened is as late as December 25, we found another buyer that is trying to sell off this property despite an injunction.
These are all submissions.
They have already made injunction application there and
file your comment.
That we file our comment.
A very peculiar kind of submission is being made.
Have given a particular.
They've given you a date.
Deeply obliged.
Deeply. No counter in this. 58.
And for the state allowance, respondent number 2, we support the stance taken by the petitioner, but we seek time to file the counter.
Respondent number 1.
I'm appearing on behalf of respondent number 1. We also see 2 weeks time.
Very well. Then counsel appearing for respondent numbers 1 and 2 seek time to file their respective counter evidence. Usual order based on safety.
Item 59.
Item 59, I am appearing for R1, 4 and 5. We are seeking time to file count.
1, 4 and 5.
Please,
I beg to appear for respondent number 2. To put in the counter, the only thing was he was a
You filed counter?
We haven't filed it.
You also want to file, Mr. Agarwal?
Because we'll file, there's actually one document, my DIR 12, which shows I'm an independent non-executive director. And really, as far as I'm concerned, that's the basis of
all the first counsel appearing for respondents 1, 4 and 5.
1, 4 and 5.
On the one hand, and the learned counsel appearing for respondents.
As per office report, R3 is
take
not
some time to file their
services
affidavits.
for R.
For the office report dated 16/1/2026, respondent number 3 still remains unserved. Steps shall be taken for completing service upon the said respondent. Rejoined us to the counter affidavits of, if filed within time, shall be filed. It may be filed within 2 weeks thereafter. List on. Dusty service was permitted last time also. Then this list you've given us, Mr. Sena, doesn't contain 10th April. 10th April is a miscellaneous day. It should be here. Not there. 14th is there, but 13th is also not there.
From tomorrow, I will.
I'm
okay.
Item 60.
No counter in this also. Counter. Who appears?
I have for the private respondent. The counter has been supplied, but it's not on record.
We've not filed it.
It's supplied to us.
Supplied to you, but not supplied to you? No. So you've only kept it to yourself there. We find that no counter affidavit has been filed till date. And counsel for the respondent shall do the needful in that regard within 3 weeks. Rejoined us thereto, if any, may be filed within 2 weeks thereafter. Earlier interim order dated 14/11/2025 shall continue to operate till the next hearing, based on 13th April.
Item 61, may I request?
No counter.
So, my lords,
Counter is not there.
I understand, my lords. Will take 2 weeks to file the counter.
Very
For any reason, my lords, I'm only requesting.
You're for the state?
Yes, lordship. Lordship, the next date in trial court is 9th of February. That's why, my lords, I was looking to press for at least to stay or definitely
No.
the trial court proceedings.
Cause is dismissed.
Yes, my lords, but my lords, we see the order issue notice where my lords noted the judgment of Mariam Fasihuddin and said that this is a case where a supplementary charge sheet has been filed without any further investigation. And the only change in circumstance was the fact that I had taken anticipatory bail. And therefore, my lords had pleased to issue notice in this matter.
What will happen in one hearing?
My lords have already appeared, taken bail out. What may proceed with
Then
arguments?
counsel, you're appearing for the state?
Yes, lordship.
What about R2?
R2 serve, my lords.
No one's appearing?
No, my lords.
Lordship, they can take up this point in the trial court as well. They will charge.
R2, no one. Served. Let them file a counter, Mr. Luther. Then counsel appearing for the state of Haryana seeks some time to file a counter affidavit. Then respond number 2 has not chosen to enter appearance despite service of notice. Counter affidavit of the state shall be filed within 2 weeks. Rejoinder therefore, if any, may be filed within 2 weeks.
Lord, I don't have a stay because last time my lord said only notice.
So nothing will happen in one hearing. What?
But give me a fixed date.
We'll give you a fixed date.
I'll take it.
27th February.
Most obliged. Item 62.
Lordship. Michael has not taken papers.
Yes, my lordship, I have been served with the copy. So
Why is it that you did not get in touch with the registry? The office report says that they were not able to contact you because you did not get in touch with them. We should have noted your mobile number in the order, perhaps. Our mistake on the last day.
Apologies,
Now you've got the papers.
I have received the papers.
Did you get in touch with the
Yes, my lordship.
respondent?
The respondent is also appearing through VC
I see.
today itself. So she is willing to contest this matter. It was surprising to it came into my knowledge that it was the first time when I have served upon her the notice. She came to know about this initiation of this appeal. Prior to that, she did not have any sort of knowledge. However, the affidavit of service says something else.
Yes. Very well. You wish to file a counter then?
Yes, my lordship.
Very well. Learned Amicus Curie appointed to represent the respondents.
Who's also appearing
Seeks- Is she there?
Yes.
Respondent seeks time to file a counter affidavit on her behalf. The respondent is also present online, though we don't see her. Though. She's there. Very well. Authentic information, it says whatever that is. So, needful in that regard shall be done within. How much time would you require?
4 weeks.
In 4 weeks. Rejoinder thereto, if any, may be filed within 2 weeks thereafter. Based on 14th.
Much obliged.
We still have the same issue. Why do you want a divorce at this ripe old age? You want to get remarried at 62, 64, whatever you are.
Lordship, it is broken down.
But what do you want to do with this divorce decree? Hang it on a wall?
No, Lordship, this is because Lordship, they are property of each party. So in case it is not that they may file the suit against each other.
Children must be there. No children?
There is
No children, Lordship. No children, Lordship. No. Date is not.
We've given our date. 14th April.
Much obliged.
No counter in this.
Lordships, I'm seeking just 1 week time to file a counter. We received the affidavit today.
Lordship, appearing on behalf of the petitioners, matter may be posted on 2nd February, Your Lordship.
Why? Auspicious day.
Lordship, instruction from the senior Lordship.
When you file your counter, let the counter come. You can pick another lucky day after that.
Much obliged.
Then counsel for the respondent seeks some time to file a counter affidavit, which will list on 10th March.
Item 64.
10th March would be too late, maybe. 16.
64 was to be taken up on a non-miscellaneous day.
Yes.
Here, my lord, 34 order is reversed in my favor, in my appeal in 37,
Very good.
and the termination is upheld.
Take it up on
Malaj, may give us a date, Malaj,
Yes.
any Friday, Malaj, in February, Malaj, if that's possible.
Non-miscellaneous days. You join the queue.
No, Malaj have been posting it on miscellaneous days, Malaj. We'll see the last
Very
few
well.
dates, Malaj.
When is the next available miscellaneous date hearing? Give it a little later so that this kind of cluttering, if it's there, then there's no point.
My lords, I think it has to be heard. It's to be on a non-miscellaneous day. Anyway, so I leave it to my lords.
Miscellaneous day, provided I don't
Yes.
run riot with the listing and we don't end up with 95 matters, you might have a chance in the afternoon, Mr. Patil.
Very well. Very well.
Well, that chances appear to be very rare. Your lordships will be flooded with
We'll
matters.
take our chances, Malaj.
Today was a disaster because solely my responsibility, but hopefully
No,
I
my
will
lord,
not.
every court faces this problem, my lord. It is.
Let us
But scattering, my lord, is the solution.
9th February.
9th February. No matters listed for hearing on this. 9th February. 9th February,
Grateful.
with the understanding it will be taken up after the hearing of the other matters listed on that day is complete.
Very well, Malaj. Grateful.
Please.
Grateful, Malaj.
Obliged.
Letter, help me, sir. Letter, Lordship.
We don't have a letter.
Lordship.
In the 2023 order, there was no stay. The first appellate court has not proceeded with the matter.
Lordship, list any date, my lord.
No. To answer the question, no stay was granted here. Matter was remanded to the first appellate court to hear the appeal on merits and dispose it of. Has that happened or has it not happened? You don't know what the case is.
Not
You don't know.
Council.
How many? You also have 95 matters today?
No, I have no.
We have 95 matters. I bother to read your file. You don't bother.
Oh, I'm sorry.
You are appearing for.
The respondent, my lord.
What, do you have any idea whether the first appellate court has taken up the matter?
My lord,
You also don't know.
I.
You also have 95 matters. Very good.
Obliged.
Council for the parties taken adjournment. They shall ascertain as to whether the first appellate court has proceeded to hear the matter, as there was no stay granted in the special leave petition. List on. Now I think we can go to May also. So 4th May.
Item 66.
Very short matter, no, in fact, the SLP is itself not maintainable. One of them is against a conceded order. Another one is not after us. Taking all the OTS fine. Covered by a judgment of this court.
One. Comes before. Council.
But this is quietly.
66.
Yes.
There is some problem in this
Someone?
device.
Who's appearing?
Who's appearing his name? Shama.
Sham Gopal. He's there online.
there is some problem.
So now you've deposited this 95 lakhs.
Long ago, it has now become 1 crore 30 lakhs already, my lord. In fact, after accepting not over and above the OTS money, they deliberately cancelled the OTS.
Your initial outstanding must have been much more than 20 crores.
22 crores, not I have actually deposited 22 crores as per the OTS.
At your convenience.
Yes.
At your convenience, you've deposited.
Sorry.
You did not deposit it within the time frame.
No, I have a table.
You were supposed to deposit the 20 crore amount.
31st of March 22 and
Yes.
with interest 31st of March 23.
Whereas you paid only 13.10 crores by 31st of March.
By 3rd of June 22, I paid the entirety. Why? Because
Once you fail to stick by the timelines, the OTS is to begin with a haircut for the bank.
Yes, I need.
And then they're taking lesser amount with the hope that you will at least cough up whatever you are willing to cough up
Let me clarify
within that time frame. And you don't do that. And then you say, no, the OTS amount is binding.
Sorry, let me just tell you, Lordship, what had happened. Let us clear this misunderstanding. One is that, Lord, the understanding was.
Not able to join.
He's logged in, Milord. He's
not able to join.
Unmute.
No, but one thing we didn't understand.
No, I don't know.
I see, he just told me. You're not there. You're not there, Mr. Pai.
I don't know what.
Actually, my lord, the understanding was as and when the amounts are clear, payment of respondents were to be released, which they didn't do. Yes, which they didn't do as per the understanding. But my lord, all said and done, amount is already there.
Has joined online but is unable to address argument.
And we need a short date because my property is.
You've already got the stay of the contempt proceedings, don't?
No, they got. They were to release the document. They had to release the document. My property is blocked, my lord, and I can't do anything with that despite all these monies having been paid. Kindly give a very short date.
By the respondent. One of the respondents, I believe, has circulated the letter. So,
no.
Yes.
Last time I mentioned and got it listed, my lord, in fact. Our side got it mentioned and listed it.
We'll see.
We never circulated any letter for this.
The list on. 16th March.
Good. Sometimes in February at least. Good. Second week of February at least. It's a very, very short issue. Amounts, everything has been paid and over above also is deposited. Now, my lord, only the suit is there.
20th February.
Very well.
Earlier interim order.
It's a Friday.
Earlier interim order shall continue to operate till the next year.
Lord, can I just pray one thing? Lord, may I make a prayer, my lord? Admittedly, all monies are received, my lord, and out of 3 respondents, 2 respondents' document have been released also. It is only one property which is the most valuable, which they are refusing to release, my lord, which is what we filed the contempt for. 2 courts have held.
You'll have to hear them.
Lord, kindly release it subject to the outcome, and my money is already there.
Madam,
we don't understand why they have scaled down the amount in the OA.
It's 90 lakhs. 90 lakhs.
Exactly. And they need to explain as to why it's been scaled down to 90 lakhs. Because once the OTS fails, then the entire amount becomes liable.
No, it was not failed because they did not oblige as per the OTS agreement, my lord.
That is again something that is debatable, is it not? According to you?
It's there on record. It's there on record. Lord, I placed it on record. 5 crores, one property.
Rather peculiar because I've never come across such an OTS.
Lordship will see. I
will make one payment, one document will be released.
Yes. That was the OTS, Lord. That was the understanding.
And was it also mentioned that after the release of that document, you'll sell that property and then make the next payment?
It's not only after the release.
Did it say that?
Therefore, yes, my lord.
That after the release of the document, you will sell that property and then make the next
payment. That was up to us to sell it or mortgage it in the bank or give it to them.
Therefore, your liability to make the payment was independent.
No, subject to the release. Subject to the release of the document.
Subject no question of your saying that I did not pay because they didn't release the document, I couldn't sell.
Yes, my lord. That was the understanding in the OTS proposal.
Let us see. Let the other side come.
Very well.
And see whether you. 67.
Leonard SG is appearing to the basic.
No, 67. Lord, the other side. Lord, landowners, Lord, sought benefit of Tarsem Singh judgment.
Petitioner's counsel is missing, so we'll have to give you a date, Mr. Solicitor.
Yes, my lord, Tarsem Singh judgment is under review. The review is heard in open court and notice is issued by the honorable bench. So your lordships may consider having it after 5 weeks, my lord.
Very well. no representation for the petitioner. Then Solicitor General states that the review filed in relation to the judgment of this court in Taslim Singh. Just trying to fill
The same thing is the 3 year. Why should we review?
Now been entertained. So,
Lord, I'm sorry, Lord, I was missed. The review was dismissed. Thereafter, I moved clarification, which is entertained and notice is issued.
but the clarification petition filed in relation thereto has been entertained.
And notice is issued.
List on 11th May.
Please, sir.
Item 68.
May please, Lord.
Yes.
Questions I have here for the respondent.
No counter affidavit.
We'll file it, Your Lordship. There are certain documents, also some reports which we need to bring.
And counsel appearing for the respondent seeks time to file. Respond number 1.
Please, my Lord. There's only
Respond
one.
number 1. And others, it says.
Others, my Lord, I'll just, the other insurance, other
Respond
offices,
number
my Lord. It's just same company.
Seeks time to file a counter affidavit along with supporting documents.
Please, my Lord. The
Which
documents.
form the part of the record.
Some reports.
Which form part of the record before the NCDRs. Usual order. List on 18th May.
Wait for me.
Item 69.
Service is incomplete. You are appearing for?
Respondent number 1, Your Lordship.
1. Who's
The counsel is, sir, the arguing counsel is in some personal difficulty. So
Sorry?
the arguing counsel is in some personal difficulty, so I request a short.
In any event, service is incomplete, but he's filed an application for deletion. Have you received a copy for? You are respond number 1, is
Yes,
it?
yes.
They are asking for deletion of the names of 2, 3, 4, 5, 6, and 8.
Yes, Your Lordship.
You have anything to say in the matter?
Your Lordship, the arguing counsel will be.
Very good. Adjournment is sought by the learning council. Hearing for respond number 1 on the ground that the learned arguing council is indisposed. List on 4th May.
Item 70.
It's in item 70,
No counter.
I need some more time because a policy decision has to be taken, my lords. Because so far as the government servants are concerned, my lords, the policy decision has already been taken, but the
No, but in terms of the judgment,
daily wager, my lords, is not covered and he's not a government servant.
You're not a government.
No, he's a daily wager, if I can.
Yes. But you made them permanent employees.
Yes, no, that is clarification by this honorable court that the word permanent is not to be construed as a regular service, my lords. There's a clarification, my lords.
What do you mean by making permanent then?
Because these daily wages, they are governed by a resolution of 17/10/1988.
No, but do you have a separate status of permanent employees?
Not
as
permanent.
opposed
The
to regular employees?
the term permanent does not.
You give them a retirement notice and a retirement order.
And
they're getting pension as well. Pension also is. Yes,
Service conditions are governed by a resolution, separate resolution.
No, but you've come up with a new service jurisprudence concept, is it? Neither regular nor daily wage, but permanent.
They are.
Very well. What is it that you want to file a counter? Then counsel for the state of Gujarat seeks some more time to file a counter. Needful in that regard shall be usual order. List on.
Your Lordship, may I mention only 2 aspects, Your Lordship. In the same issue, the Honorable High Court directed them to file reply with regard to 2 judgments of this Honorable Court, where say that the 1988 circular made regular means they are permanent employee. You give reply to. They haven't filed reply in High Court as well. There are 2 judgments. Let them.
It's an order of this court,
Let them
Yes,
that's right here. It's the 17th day.
Indeed.
Item 71.
Service incomplete.
71
complete.
Yes. Lord seeking 4 weeks time for filing counter.
For which
For R6, my lord.
R6.
New India Assurance.
Service is incomplete as per the office report. So please look it up and whoever needs to be served, take steps. Office report dated 16/1/2026 furnishes the details of the Respondents in this batch of cases who remain unserved as on date. Necessary steps in that regard shall be taken by the learned counsel for the petitioners. Learned counsel for
R6, respondent number 6, my lord.
respondent number
I am
4.
appearing for respondent number 2 in 71. In 71.1, I have file counter. 71, I need to file counter.
Respondent number
2 in 71.
Respondent number 2 in SLP in item 71. And you
Respondent number 6, my lord.
in 71?
Yes, ma'am.
In 71. Seek time to file the counter evidence. Usual order.
Great.
Based on 14.
Item 72.
71.1 is also there, my lord.
Yes. 71.1 will go with that.
There, my lord, I am respondent number 9, my lord.
You need to file a count. Respond number 9
In 71.1, my lord. Grateful.
72.
May it please me. In 72.
Some application you filed for deletion and the other side wants to oppose
Counter has
that.
been filed.
Counter is filed now.
And last occasion, they took time for arguments on deletion petition, Miller.
The deletion is, my lords, of my co-plaintiffs who are respondents.
We'll pass it over. In the event we have time in the afternoon, we can take it. Matinee show today.
Some difficulty at my lords.
Where is it? How long do you propose to take?
Lordship may,
If you finish by lunchtime, both of you, then
there's a 12 to 3 show also, and 3 to 6 both are a little difficulty today to argue, my lords. If your lordships may accommodate me, otherwise, my lords,
very good.
yes.
Some other day.
SLP itself can be held, my lord.
Miller, matter can be disposed of, Miller. The simple questions are involved, only question of law, Miller.
Today we are a little hard pressed, but afternoon we could have accommodated because I didn't expect to get to item 72 by last
Even the
time.
bar didn't expect me.
All fields are completed, Miller, but please, short questions are involved.
Where are you off to, Mr. Dave?
No, I have 2 matters.
You have 2 matters passed.
Not off. That luxury is not there.
That luxury is not.
Any Monday afternoon, your lordships may fix it. I'll argue it, my lords. You want it argued? Well, then lordships may fix it today only. My learned friend will argue. I may not be there.
Very good. Then we'll pass it.
Obliging.
Item 73.
May I please, your lordship? Your lordship, on the last occasion,
Issue notices to Devasthan department.
no one enters appear in this matter, my lords. The service is complete, my lords.
No, my lord. My lord, Devasthan department is not appearing, my lord.
My lord, the service is complete,
But no one is appearing.
my lords.
That is the usual course of affairs in this court. Is it not? States do not choose to come.
My lord, may I say this?
Is there a designated standing counsel for the state?
Yes.
Your Lordship, I am appearing for the state. We seek 4 weeks time to file.
Why are you keeping quiet then? Waiting for the focus to turn upon you. Till then you thought you might get away without having to open your mouth.
Apologies.
Learned counsel appearing for respond number 8 from the state of Rajasthan. 6 time to file a counter affidavit.
With regard to the status of temple, my lords.
Counter affidavit with regard to the status, counter affidavit with emphasis upon the status of the subject temple.
My lords, I'm so grateful.
Usual order after that, then 20th month.
My lords, I'm so grateful.
Item 74.
74, trustee service is there and no one appears. Union of India. Union of India, no one appears. Come for the petitioner. No representation for the petition. Is there? Is there? What is everyone is having a problem. Our side problem is it? We are having a problem. We are informed that the Learned Counsel for the petitioner has joined online but is unable to appear due to a glitch in the system. We find that the Union of India has not chosen to enter appearance before this court despite service of notice. Learned Counsel for the petitioner is permitted to effect service upon the central registry to ensure that there is representation for the Union of India, at least on the next date. List on.
Item 75.
Safety.
Your Lordship,
No comment.
requesting, yes, I'm requesting for some time to file it.
You're for which respondent?
All the respondents.
All of them?
All of them.
And counsel appearing for the respondent seeks time to file a counter affidavit, truthful in the usual order. Is that foreign exchange issue?
Yes.
April.
Very grateful. Very grateful.
Item 76.
Yes, I am appearing for respondent number 1. I filed my
No counter.
Lords, give me 3 weeks minutes. I'll put my counter minutes.
One counsel appearing for respondent number 1. What about the other respondents? Are they served? There's only one
Yes,
more.
sir.
There's one more respondent.
The performer respondent.
And no minutes.
Served any.
Like they say performer.
Respondent number 2 has not chosen to enter appearance despite service of notice.
The respondent number 2 would have a critical role minutes. In fact, High Court,
if he doesn't choose to come,
specifically directed them to include respondent number 2, in fact, in section 11 stage.
Counter affidavit, respondent number 1. Usual order, list on 10th.
Obliged.
Obliged.
77.
No, so like to pay for the petition, the present
I'm
matter.
appearing for
Respondent number 1, I'm trying to 4 weeks to file it out.
Main counsel for respondent number 1. You also want time? Then counsel for respondent number 1 and the then counsel appearing for respondent numbers 2 and 3. Seek time to file the counter affidavits. Usual order after that.
Must be also not stand to file a rejoinder if necessary.
Rejoined also. 6 day.
DPA.
Item 78.
The respondents have been served.
Someone is appearing also.
My lords, I appear for respondent number 2 and 4, State Bank of India and Indian Bank. I'm seeking time to file my reply, my lords.
2, 3, 4 other banks.
State Bank of India is there.
Yes, my lords, I appear for the State Bank of India.
Financial implications
Yes.
are there?
My lords, it's a case
Yes,
of
my
a
lords.
personal guarantee.
No.
Financial-
State Bank of India
Is a
stands
consortium.
to gain financially.
Yes, consortium.
This before a bench in which one of us, I don't know, not remember.
Please give us time to
Grateful, my
file
lords.
We are listing it before a different bench. So you-
Obliged.
Grateful, my lords.
Item 79.
My Lord, 79 to 83 are after
All those
notice matters.
from
My Lord, I'm
Madhya Pradesh.
praying for some time to file counter affidavit.
Very. And counsel appearing for the state.
I'm for
Also for the
State and
the corporation, the mining corporation.
then counsel appearing for the respondents. Seek time to file their respective counter affidavits. Needful in that regard within
The interim order can be extended.
17th April. Earlier interim orders should stand extended till the next hearing.
They can
Up to
all,
83.
they can be tagged together. man.
One item. Tag them.
79 to 83 may be
Why they are
tagged.
not?
Yes.
Great. Tag all these matters together. Up to item 80.
79.
And one matter, there is
79
no
to
interim order.
83.
79,
One matter, there is no interim order.
There's no.
One of my matters.
Earlier interim orders,
Yes.
if any, shall continue to operate till the next year.
Great.
Wherever they're there, they'll continue.
Yes. Lordship.
Item 24.
'84. Yeah, 84, IA number 316492 of 2025. The delay in the filing of spare copies is unknown. The registry may take steps for effecting service of notice upon the respondent list on 13th April.
Very good.
Item number 85.
The Lordship,
Counter is filed
counter was served on Saturday.
yesterday.
Yes, Lordship. And seeking some time to file the rejoinder.
And counsel for the petitioner seeks time Petitioners seeks time to file. There's only one petition. Petitioners seeks time to file a rejoinder to the counter affidavit.